In the facts and circumstances, the matter stands adjourned till 29.
Lordship, I was praying till 26th of April 2026. However, if your Lordship deems it, actually, falling from your Lordship's wisdom, if your Lordship deems it fit to keep it sometime prior in time, I will not come.
When do you want to?
But after 10th April 2026, it's almost 9 months, your Lordship, I'm praying.
If your Lordship allow that liberty to mention,
Uh,
then we
I am the decree holder. They are asking for liberty to mention.
Okay, then
I'm
let this
self-esteem.
matter appear anyway. Let it appear after the vacation.
Grateful.
Let this matter appear.
Puja.
Matter appear. I'm just giving the date also. 6/11/2025.
Very grateful, your Lordship.
Lordship, I'm appearing on behalf of the degree holder. Your Lordship, on 17th of June, last chance were given to the judgment debtor to file the affidavit of assets.
In a good shape, Milord.
But
I am not in a good shape.
till now
that
we
was
have
the
not
direction,
received any affidavit of
Your
assets.
Lordship. And Milord, in this matter, I am being led by Ms. Manju Agarwal, and its senior advocate, Milord. She, on the last occasion, had appeared on behalf of the decree debtors, the judgment debtors, Milord, and sought for time to file the affidavit of assets.
Your Lordship, multiple time have been given.
It was supposed to be filed by
By
3rd
3rd July. Multiple times
have
have been
not
given.
been able to, Milord, comply with the direction. It would not be correct in saying that multiple times. That was the time when your Lordship had passed the direction.
So 17 days have passed.
Milord, 3rd July I was supposed to. Today we are
July
Milord,
passed.
yes.
The
3rd July.
judgment data was
But,
filed by 3rd July.
I'm also facing a difficulty.
But your Lordship, it was from 7th of October 2024 they were given time to file the affidavit of assets.
Have you served on us?
Yes.
Served on the advocate?
Yes, we have already served when we have mentioned.
Milord, I would be, Milord, I am told, and I have been briefed in this matter today morning. I am told that the affidavit of asset is ready. But the copy of the execution petition, Milord, is misplaced from the office of Miss Manot. I will be requesting my learned advocate, Milord, my
Your
learned
Lordship, I'm
colleague, to kindly give me a copy of the
You
cost
can
diary.
take that responsibility. I can keep it within few days.
Yes, your Lordship will keep it next
I'll
week.
request her also to serve
Yes,
a copy
Milord,
of that
Ms.
execution.
Agarwal has requested me for not this week because she is having some personal difficulty. Her sister is getting operated. So kindly keep it next week, Milord. This direction will
today
possibly be
was
complied.
fixed.
Kindly
Your
give me the
Lordship,
copy of the
kindly
cost
give
diary.
some cost at least.
Let us come back, Milord. We are taking the Lordship has given me the responsibility. I will discharge.
Although learned advocates for the degree holder and learned advocate for the judgment debtor are present, although several opportunities were granted to the judgment debtors to file affidavit of assets, but the same is not complied. Best known to the judgment debtor. However, as the learned counsel appearing for the judgment debtor submits that a few days time be granted so that the affidavit which is ready may be filed. In the interest of justice, the matter stands adjourned till 24/7/2000, next Thursday.
Milord, may it be on 28th. I am in some difficulty on 24th, 25th,
And 29.
29th.
29/7/2025.
Your Lordship, our interim order is getting expired. Was expired on 3rd of
Interim
July.
order granted earlier stands extended for a period of 6 weeks or till further orders, whichever is earlier.
I'm out. Madam, একটু wait করবেন, আমি just একটা copy একটা ছবি তুলে রাখবো।
Item 80, for the judgment debtor. Lordship, we had preferred an appeal which was heard at length on 17th of June. Thereafter, the matter was.
Application is this GA1?
GA1 is their application, Lordship. Lordship, we had preferred an appeal. The same was heard at length on 17th June, and the same was reserved for judgment, Lordship. It has not been decided yet. I'm praying.
What
if
was
the
the
matter.
earlier order? When was this matter taken up? Let me see.
This is
This was 24th June.
24th June, Lordship.
Anyway, let some time be granted. Let's see. And its advocates for the parties are present as the appeal which is preferred against the decree has been heard by the Honorable Appeal Court and the judgment is reserved on
It was reserved on 17th of June.
on
17th of June.
17th of June 2025.
18th.
In the interest of justice, the matter stands adjourned till 5/8/2025.
Grateful, Lordship.
Achha.
Okay, let it be 7/8. 5/8 na? 7/8 for the 7/8/2025.
Grateful.
Your Lordship, I'm appearing for the respondent.
My lord, pursuant to your lordship's direction, the decree has been executed and we have taken peaceful possession. My lord, will record that and
Your Lordship, I wanted to submit something. Your Lordship, in your Lordship's order, there was no direction for police help, Your Lordship. Despite
the-
that,
No, no, what was the earlier order passed?
today was a date. On that date, it was said, Your Lordship, to issue the direction was issued upon the sheriff to file a report.
Just a minute. Moving sheriff. 15th July was fixed for report of the sheriff.
Yes,
Yes,
Your
sir,
Lordship.
come.
Sheriff-
But Your Lordship,
Possession.
the very well, Your Lordship. But then in your Lordship's order, Your Lordship, there was no direction for police help. Despite that, Your Lordship, many hooligans had come to dispossess my clients from their property. They were not even allowed to take out their belongings from the property, Your Lordship. My mother, who was
My lord,
76
before my-
years old, Your Lordship,
For my
she was also
management
not being.
submissions, there is a letter of his own client, of our own client, saying that we are giving you possession peacefully. Letter. go
Anyway,
through this letter.
here there is no mention that there was
Yes.
any law and order problem
Nothing.
in the report of the sheriff.
We have the video also. They have peacefully handed over and gone, and this is the letter which they have given.
Yes, learned advocate for the degree holder and learned advocate for
I
the
will-
judgment data are present
तो बोले ही नहीं उन्होंने।
in terms of order dated 19th June 2025. Directing the writ of possession
Copy of this, please.
to be issued by removing the judgment data, their main and legitimate servants, the scheduled property of the tabular statement. Such order has been complied and the report has been submitted by the deputy sheriff on 14/7/2025. Stop. As the decree has already been executed, nothing remains to be decided in this case.
My lord.
Thus, this case stands disposed.
My lord. Bless you.
I appear for the applicant in GA 1. Lord, your lordship will recollect, this is that matter where my learned friend had sought execution of a decree.
Here one, whose application?
My
My lord, that is a judgment data's application, my lord, for dismissal of the execution proceeding.
execution proceedings, my lord, on the ground
I
that
think I've heard this matter.
Yes, my lord.
we
I-
were to
Mr. Dotto
Yes.
took some time.
Yes, my
we
lord.
were
Consider
to
Justice Patronak's decision
Yes, my
and
lord.
submit the written notes. Nothing remains to be further.
I have already filed my written notes, my lord.
So
we have also filed our written note, my lord, but
you have
only
considered Justice Patronak's judgment, all have been dealt with?
no, because that was filed on the day when they cited this judgment.
No, but thereafter so many days have passed. I think 2 weeks ago I have heard this matter.
Yes, my lord, your
And
lordship had-
granted the opportunity to consider the judgment and come ready.
and make submissions on that, my lord.
You make submissions well and good. Otherwise, if you want to deal it in your written notes, I can grant you opportunity to deal with that on the next day.
We'll do that.
Yes, learned advocates for the parties are present. Written notes of arguments have already been filed after conclusion of the hearing. However, learned advocate for the judgment data prays for time to submit a supplementary notes of arguments.
Dealing with the judgment that they had said.
Whatever supplementary written notes of argument dealing with the subsequent judgments passed by coordinate bench of this court, such prayer is allowed. Time to submit the supplementary written notes is granted till 24/7/2025. Let this matter appear on 24/7/2025.
Much grateful to my lord.
Indeed.
petitioner, my lord.
Right.
And this is the matter your lordship will recall.
I think you have submitted and there's some settlement proceedings were going on.
Not question of settlement.
That matter.
Yes, yes. And your lordship will
The
recall.
Vishnu Chaudhary
Yes,
have been-
Yes, my lord. He was
I
reading
just
in.
tell your lordship my lord, what needs to be done. This cannot be termed as an adversarial proceeding now. Because my lord, the probate proceeding, the partition suit was settled by way of a terms of settlement. All obligations have been performed except one. That is, my lord, certain shares
What is coming in the way?
coming in the way, my lord, is ego. He is, my lord, the relative of, is a very close relative. That is why the ego issue comes in.
You give some suggested orders. Or
Yes,
something.
but what I was suggesting, my lord, kindly see, the bank, the shares were standing in his name at a stage when it is in a physical form. So it was agreed that he will have it transferred to my client. So now, my lord, we had requested them, they have given a no objection.
Yes.
But when we forwarded that no objection to the State Bank of India for rallies, the companies whose shares have to be transferred, he said, my lord, that simple no objection will not do.
Yes.
They gave certain criteria. My lord, kindly see, my lord, page 54 once. These are the things which came from State Bank of India. Kindly see page 54. Yes, kindly see. This is the share transfer agent of State Bank of India writing. Kindly see after my client's name, Unit State Bank of India subject transmission. This has reference to documents executed by you in connection with transmission of shares. I gave them all those documents which came from them. On scrutiny of the documents, we find the following discrepancy. KYC documents, self-attested copy of PAN, Aadhaar from surviving holder Monisha Chatterjee and Siddhartha Chatterjee required. NOC Appendix D from both surviving shareholder Monisha Chatterjee, Siddhartha Chatterjee required. Indemnity to be executed by the claimant, Appendix C in cases of family settlement. So, my lord, I gave them a letter saying, my lord, kindly turns the next page, page 55. I am writing to Siddhartha Chatterjee and Monisha Chatterjee. But I have said, my lord,
It's a long time, 1 year ago.
yes. Now kindly see. This is my letter. Then they write to me on page 57. They say that you have not informed the executor. So all these things are going on. Then, my lord, I have given my advocate's letter also. Page 59, your lordship will see. Specifically in paragraph 3, I have said that these are the things which the bank requires. I have no choice here. And I have forwarded page 61, these forms also which came from the bank. My advocate on record has said. And so, my lord, this is the problem I was suggesting, subject to what my learned friend, what falls from your lordship, my lord. Let my advocate on record be appointed as a special officer. He will write once more to the bank and the companies a final request. What are the documents you require for transfer? Once the bank intimates, he will forward those documents to my learned friend's client. And let my learned friend execute those documents as per let it be done through the special officer, my advocate.
Why your advocate on record? Why not a third party?
My client is not in a position to bear the expense. They are.
Let some junior member be appointed.
Does it? I have no
My lord,
objection.
before my lord passes the order, I'll just indicate. I am for the judgment debtor number 1.
Yes.
Judgment debtor number 2. Sorry. Judgment debtor. The judgment of number 1. Now, only thing is the terms of settlement. I've taken instructions from my client. Whatever is stated in the terms of settlement, he's ready and willing to do that. If my lord kindly takes page number 22 once, this is the terms of settlement which is sought to be executed before my lord. Kindly sees my lord page number 22. The terms of settlement begins at page 20. And my lord, one of the clauses, my lord, kindly see the bottom clause 6, Roman 6. With regard to the shares mentioned in clauses such and such of the affidavit of assets, so the parties have agreed that Siddhartha Chatterjee or Monisha Chatterjee, my clients, as the case may be, whose name appears as a shareholder in the shares mentioned in clause 7, shall issue a letter to the appropriate authorities of the respective companies recording their no objection. Kindly seize, my lord, recording their no objection to the transmission of the respective shares in the name of the executor to the estate of Bela Chatterjee. Similarly, my lord, will kindly see clause number 7.
Thereafter, my learned friend should read, the executor upon such transmission shall take steps for deed and transfer the same to.
Whatever is there, you see,
No,
that is there.
Yes, my lord. So, my lord,
Let
we'll
us
have to
consider
follow.
the subsequent development, that is July 24.
Yes, my lord. What requests we have received, kindly, which my lord is at page. Kindly seize, my lord.
59.
59.
But
Kindly
my
seize.
point is,
My
ultimately
response
the
is.
shares will have to come to me.
Yes, my lord. May I just
Even
indicate
if
what
it
is the
stays
problem
in
that is.
vacuum, his client will not benefit out of that.
I will not benefit out of
Then
that. May I just indicate the terms of
just
settlement?
a
In
technical.
plain and simple words, there was one title suit and there were 2 testamentary proceedings. I'm just indicating. All the 3 proceedings, my lord, were disposed of by the common
Yes.
terms of settlement.
And he has got
And
nothing
the parties that
left in the lurch.
does not matter, my lord. May I just indicate the parties agreed that because there is testamentary proceeding, my lord, no testamentary proceedings cannot be settled, my lord. There may be a terms of settlement which may be kept with the, my lord, record, and my lord, probate is granted.
Yes.
Now, once a probate is granted, the executor is under statutory obligation to file accounts and inventory, my lord. That is why, my lord, it was agreed whatever shares were going to my learned friend's client has to go through the executor. I have executed the no objections where I have stated that I have no objection to the shares being transferred in the name of the executor.
I have done the
And
deed of
after that, may I just indicate, after that, the executor will take steps to transfer. I am not involved there. Now, what happens, my lord, we'll see that there are 2 judgment debtors before my lord. I am representing one. My lord had already passed an order on an earlier occasion that the other judgment debtors should be served. The only thing is that there is a medium or a conduit, that is the executor. I will transfer to the executor will transfer to her.
Let him do
All
what
the
he
requests that
wants.
I have received, is for direct transmission of the shares in favor of my learned friend's client. That would be a direct violation of the terms of settlement and the
Cannot be.
decree.
How can it be a violation?
Because clause 7 simply
My-
states that
my-
it has to be done
my
in
lord
favor
has
of the
to read-
executor.
My lord has to read the terms of settlement purposefully. My learned friend has also to read it purposefully.
Yes, and can this
Executor
purpose
will-
be granted effect to, my lord?
Executor will not.
Of assent from executor.
This I have given.
My lord, what my learned friend is trying to do, my lord, is to get the executor away from the
Well, let us forget it. But if my learned friend wants to do it to the executor, let him do it within a specific time.
I am indicating this, my lord.
And
If
your
my
lordship,
lord,
keep the matter pending.
my lord,
Let a special officer be appointed that request also I gave him.
I have
that
no problem.
my
I have no
intent-
problem.
My
So, just a minute, let us come to your letter, that is
Yes,
59.
59.
In terms of letter dated 59, this Monisha Chatterjee, that is your learned
No,
friend's client.
there
Well,
are
judgment
clients,
debtor,
there are
my judgment debtor number 2 is my lord Siddhartha Chatterjee. His wife is
wife.
Monisha Chatterjee.
not involved here.
This 59, this page 59 is given by your client's,
My lord.
your advocate on record,
My lord.
Yes.
so that this
This
documents can be
compliance-
executed.
Yes, this compliance can be done.
So at present, you are suggesting is that a special officer be coordinate with the bank.
Coordinate with the bank and the
Not
share
object-
companies. Ascertain what are the documents they have to sign. Collect those documents from the bank and the companies, give it to them, obtain their signature, then have it transferred.
My lord, I do not have any objection to that suggestion, man, provided I am transferring the shares to the executor, the other judgment debtor, and the executor is transferring it to him. My lord, I have no objection. Special officer, receiver, whoever my lord appoints, I have no objection.
In saying, well,
But I will be
let-
giving my no
let the
objection.
Advocate on record do it, my lord.
I don't have any objection, my lord, to that, but provided I am executing the documents for transmission of the shares in favor of the executor. Thereafter, my lord, I am not in the picture anymore. Then it's
Yeah.
between the executor and the
Executor cannot get the titles.
Assent
This my learned friend has to
the
appreciate.
decree of
Advocate
court,
for
my
the
lord, unless the decree is
decree
set
holder,
aside or modified.
Learned advocate for the petitioner,
Yes.
Decree
And-
holder.
the learned advocate for the party are present. Is submitted by Mr. Sen that although terms of settlement were executed along time before, and his client has performed his obligation. But from the side of the opposite party, the obligations are yet to be discharged.
My lord, I'm disputing that submission. Kindly records that.
Which is disputed by the learned advocate for the judgment debtor. The same draws attention to the letter dated 27th August 2024, addressed by learned advocate of the petitioner to the opposite party with a request to issue a no objection in the format provided by SBI for the purpose of transferring 40 was now 400 numbers of SBI shares
Well, there are other shares also, my lord.
In
Kindly
favor of client, my lord, that is what
along
my
with the
objection.
self-attested KYC.
My lord, in favor of the client, that is the decree holder, that is where my objection. It cannot be a direct translation.
As well as the no objection in the format that's provided by SBI for transfer of 100 numbers,
bank will not do in favor of executor.
1000 numbers of SBI shares along with affidavit. Self-attested KYC. Is submitted by learned advocate for the opposite party.
My lord, judgment letter number 1, because there are two judgment
One
letters.
opposite party. Client is ready and willing to do the needful in favor of the executor.
My lord.
Stop. In the facts and circumstances, this court is of the view that a special officer could be appointed for necessary queries from the bank authorities.
Bank also, my lord, kindly note rallies. Yeah,
Bank
because there are
authority by which bank?
State Bank of India. The shares are of State Bank of India,
State Bank of India,
comma rallies
as well as rallies,
and UTI.
UTI, as to the relevant documents which are required to be executed, implement the terms of settlement. Yes, when is the terms of settlement?
Yes, my lord, kindly provide that clause. As
Terms of settlement, my lord, I'll just indicate page number 20. My lord, find the date.
page number 22, Roman 6.
My lord, 26, my lord, the date is 19th of December 2018.
Kindly come to
26.
Page
Page
26.
No, no,
Date জানতে চাইছিল বলে বলছি।
Terms of date of the terms of
My lord,
settlement.
26, page number 26, my lord, we'll see at the bottom, it was signed on the 19th of December 2018.
Yes, 19th of December 2018.
Yes, 7 years now.
Entered into between the parties. Yes, which documents? The special officer, that is the document addressed by the bank and the company.
Yes,
The
sir.
documents is there in your petition.
No, they have, those documents kindly see, my lord, Rallies has also said, well, your lordship will say that they will inquire from the Rallies and UTI and State Bank, which your lordship.
Upon causing necessary inquiries from Rallies Company and State Bank of India, which branch?
These are shares. Shares
Okay,
are
State Bank of India. The learned special officer shall intimate the same to the judgment data number 1
As well as my lord 2.
and judgment data number 2 for taking necessary steps in accordance with the terms of settlement. On issuing the intimation, the learned special officer shall submit a report before this court on or before 12/8/2025. Learned special officer may, for expedience, may for convenience, issue notice upon the learned advocates for the parties to cause this inquiry to be present before the authorities.
But after the documents are collected by the special officer, they present it to the judgment debtor for their
That will be done.
examination.
Thereafter, he shall submit the report.
Yes.
But
After
this inquiry may be caused upon notice to the
Yes.
can be done.
advocate of the party.
Advocate for the party.
I'm grateful. Just indicating, my lord, the judgment letter number 2 will not be in Kolkata till 16th of August. See, after that.
Let us send his advocate. He'll be
Yes,
there.
yes. That
I've kept you on 12,
12th, my lord.
Alright.
I'm extremely grateful to my lord.
12/8. 12/8.
Only 7 issues, my lord.
My lord, I appear for the
11:30.
My lord, today we are in some difficulty. If your lordship can takes it up next week, my lord.
22.
22, I am there.
27, that 11:30 fixed matter.
Oh, 11:30.
Kindly take it up next week, my lord.
Yes, 11:30. I'm adjourning it.
Next Tuesday, your lordship can keep it, my lord. We will do that.
First number item. Mr. Said appearing for the
Judgment debtor.
judgment data
Judgment.
raised for time in this matter, and the same is allowed. The matter stands at John Hill 24/7. 24/7/2025.
Item 22 is, my lord, mine.
my lord, I appear for the judgment debtor in item 22, appearing virtually, my lord, today.
The decree holder, my lord.
22.
Item 22, my lord, I am for the decree holder. This is an execution of a money decree, my lord, arising out of mean profits, my lord. And I'm only praying, my lord, let this matter stand over for 2 weeks, my lord, as my lord, appeal is pending, my lord, appeal hearing is going on. So there is an understanding between us, my lord, that we shall not proceed here, my lord.
I am grateful to my learned friend. That's the understanding, and I
We shall, my lord, only.
Learned
also pray that 2 weeks, my lord, time be granted.
advocates for the
31st.
parties are present as an appeal is preferred against the
My lord,
decree.
may I only this, my lord, this was your lordship's last order, my lord. Lordship may not record that, my lord. It's just, this is in a bunch, my lord. I'm sorry, my lord.
Advocates for the parties are present as an appeal is pending against the decree passed in the suit. In the interest of justice, by consent of the parties, the
May I only say this, my lord, lordship may not record that appeal is pending, my lord. There is no formal stay. So, my lord, it is just,
I'm also
my lord, lordship may
busy.
kindly adjourn it only on my,
There is a stay, no question of this court proceeding.
my lord, there is no stay, my lord. Stay petition has been disposed of without any stay. They have not deposited any money, my lord.
No, for my lord had granted us time to put in
Yeah,
affidavit
for
of
2
asset.
That is all, my lord.
Passed in the suit, although there is no order of stay, in the interest of justice, this matter stands adjourned for a short period to grant opportunities to the parties to obtain necessary orders from the appeal court. Let this matter stands adjourned till
31st, my lord, 31st of July. The 2 weeks, I think, my lord, hearing is on, my lord, only we shall be replying.
5th August, 5/8/2025.
My lord, only my lord, one
I-
question, my lord.
Appeal is pending, my lord. Later, my lord, they will come up and say the appeal is there. My lord, there will be a lot of, my lord, problem. I mean, only,
Have granted opportunity to
Lord, I
obtain
understand
necessary
that, Lord.
orders.
my lord, I understand.
If you are unable to obtain necessary, if the judgment debtor is unable to
My
obtain
lord,
necessary orders, this
even
will
on the
proceed.
last occasion, my lord, similar prayers were, my lord, made. Your lordship was pleased to record that, my lord, only simply sit at adjourning the matter. I'm only beseeching your lordship about that, my lord.
My lord, otherwise it would
all
mean
this,
that I
my
have
lord,
to go
we
to
will
the
not have
appeal
a
court
problem,
and
my
pray
lord.
for a stay, my lord.
Kindly, my lord, lordship may not record it, but otherwise it will be misconstrued, my lord, later, my lord. Kindly, my lord, lordship
I've
pass.
already recorded, although there
Lordship
is
may
no
kindly-
stay of the order.
I know that, my lord. Lordship may kindly simply sit and, my lord, adjourn the matter, my lord. It's my humble request, my lord, humble appeal.
On the prayer of learned
I'm
advocate,
grateful, my lord,
the
extremely
matter
grateful.
stands adjourned till 5/8/2025.
I'm extremely grateful, my lord.
Grateful, my lord. Grateful.
I am for the decree holder, my
My lord, I appear for the decree holder in item number 23. My lord, the last date, my lord, one of the, my lord, applicants who wished to join the decree holder, my lord, prayed for time to put in a supplementary affidavit.
My lord, I appear for the state. My lordship recalls, this was an award, which is being executed, and because the division bench appeal was dismissed.
Opportunity was granted.
Yes, my lord. So, your lordship wanted to say.
opportunity was granted to my
Yeah,
learned
my lord,
friends,
obtain
my lord,
necessary
for
orders.
going
Yes, my lord.
to
So, my lord,
on
this I
Supreme Court, my lord.
My lord, we have not been served with any order passed by the Supreme Court staying the operation of the decree.
Petition has been filed, my lord. We'll have it listed, my lord, at the earliest, my lord. Just kindly grant us some more. It's been filed.
আমাকে একটা copy দাও।
That a copy, sir.
দিচ্ছ।
Oh, yes, LP.
একটা দাও।
Information slip.
একটা দাও।
Information slip, a copy to the. My lordship, my lord, gives me just 4 weeks time, my lord.
My lord, I am opposing this prayer, my lord.
Because-
Time and again, my lord, on the ground of this SLP, my lord, time has been granted. There is no stay, my lord.
It's been filed, Lord. We'll not immediately mention it. Lord, the defects have to be cured. But Lordship gives me about 3 weeks, Lord. I think we should be able to.
Kindly keeps it after 2 weeks, my lord. Otherwise, they will not take steps.
For the degree holder and learned advocate for the judgment are present. Let the additional supplementary affidavit filed by your file for for the added party be kept with the record. Copy be served.
Copy has been served.
By the sinner, learned advocate appearing for the judgment data that additional petition is pending before Honorable Apex Court. The matter is due to appear.
We'll take steps, Lord, for listing at the earliest.
We praise
No
for
date is yet
time
fixed.
to obtain necessary orders from the Honorable Apex Court in the interest of justice. The matter stands at until 7/8/2025.
3 weeks. Okay. Very good.
My lord, please, my lord, consider providing a default clause. My lord, every time we are praying for this, should they fail to obtain a stay, this is an execution proceeding and there is no embargo for the court to proceed with the execution unless there is a stay. So please, my lord, consider this request or prayer for incorporating a default clause.
Your Lordship has already made it clear.
At least let them get one chance. there.
Yes, my Lordship.
My lord, last 3 days, Lordship was very kind to give the state, my lord, this opportunity, my lord. They can't, my lord, take the
We
degree.
could have just opened on Monday, Mr. Dotto. I'm not. My lord, nothing to do with the matter, but my lord, it's very good to see your Lordship, my lord, sitting here, my lord, and in this attire, my lord. We had missed this. This was not happening on the original set, my lord. We're very happy to see this happening again.
So I intend to maintain it.
I'm very, very grateful to your Lordship.
I appear for the degree holder, my lord. It's an application for execution of a decree arising out of a defamation suit. Lordship, decree is dated.
Yes, you are Mr. Vitro.
His personal matter.
No, you are appearing in which matter?
Yes, in this 24,
For the decree holder.
the decree holder. I've got a decree for 1 lakh damages in a defamation suit. I've communicated the decree. They have not. Kindly see page 5 of my application. Para 15.
Yes.
14 is the oral. I was examined. Oral and documentary evidence. The decree was passed in my favor of 1 lakh. A suit for damages, general damages.
So it was communicated on?
Yes.
Yes, 21st February 2024.
Yes.
No appeal preferred also?
No appeal preferred.
Yes.
An order was communicated, demands made, paragraph 17, 15th May 2024. Within 2 years, my lord, I made the application, so there is no need for service. Next party. They have knowledge, they have once appeared in the suit also.
The degree was communicated. It was a contested degree or ex parte?
Ex parte decree.
Ex parte degree.
They did not file a written statement.
Anyway, it was communicated.
Yes.
Where is the communication?
Page 7, para 17.
Para 17.
Page 5.
5.
Page 5, para 17. In spite of demands being made by the decree holder through its advocate letter in 15th May, judgment debtor has failed, neglected.
Have you annexed that copy of the demand letter?
I have not annexed the copy, my lord.
So you file a supplementary affidavit regarding annexing that letter?
My lord, I will produce the letter before your lordship. আছে সেটা তোমাকে একই জিনিস জিজ্ঞেস করেছিলাম বেশি ওস্তাদ
Okay, I am granting you time. Okay. Learned advocate for the Mr. Mitro, learned advocate for the degree holder is present. Art Mr. Mitro. As a supplementary affidavit is required to be filed and opportunity is granted to file supplementary
in 1 week, my lord.
affidavit on or before 24/7/2025. Let this matter appear on 29/7/2025.
24th পারবে তো ঠিক আছে তো কোশ্চেন নেই নাকি খারাপ অবস্থা বলো আমি দিয়ে দিচ্ছি টাকা অনেক বাকি আছে ওখান থেকে অ্যাডজাস্ট করে নেবো Similar in the next 125, same order can be passed.
25. Okay, 25 also same order.
Suit for day. I was called to the witness box. I gave evidence. And thereafter a decree was passed. Not that just happened. I went to the witness box. In my jacket and tie, I gave evidence. Decree was passed. Communicated to them. And no, my lord. Now the whole thing is, don't do anything. Don't file it in statement. Wait. Let decree pass. Then I will make an application for setting aside decree and extension of time to file it in statement. I get time in my hand. That is a new strategy adopted by many persons. Don't file it in statement. Don't answer to the summons. Don't answer to the summons. Don't file it in statement. Just sit on the fence and watch the proceedings. Once a decree is passed and the execution application is made, money decree, then you make an application for setting aside the decree and filing extension of time to file it in statement. Pay a paltry cost. Decree may be of several lakhs. You pay 10,000 rupees cost and you.
And you are appearing in 25.
25 I'm appearing.
So 24 is your personal matter. So 25 you are appearing.
I'm appearing.
24 your junior is appearing.
Yes. Somitos Doctor. Also the advocate on record, his name is there. He is appearing.
So he will either he or his senior, some other senior.
He will appear. He will appear. He knows everything. Or some junior may appear also.
And
not
so for 25 years, 25 you can also
I can appear. 20. There is no unity of personality so far as wife and husband is concerned. No unity of personality.
So for 25 is concerned, you can appear. Yes.
Same order is passed.
Yes, same order.
I'll file supplementary affidavit annexing. I'm grateful to you.
26.
And for the judgment debtor, I wanted a copy of the application. This was appearing for the first time.
They are not appearing.
But next time, if I miss, my lord, because I have not yet been served, if my lord kindly records it and records their absence and then directs my lord, because my lord is not
Just let it be not today. Let us see on the next day.
very well, my lord.
And let John call for the
I appear on behalf of a group of respondents.
That matter, my lord, where we have filed an application for preliminary decree, my lord. Mr. HON'BLE was arguing the matter.
Oh, that
matter.
partition suit.
Personal difficulty, my lord, he is unable to attend the court.
Can you let it be not today? Kindly take it out next Thursday.
Any day, my lord, I do not
On
know.
the prayer of learned.
Next Thursday, my lord, I have some personal difficulty. Next Tuesday. Tuesday next.
Coming Tuesday.
Coming Tuesday.
Yes, coming
29, 22nd.
I'm praying for
22nd.
On
22nd.
the prayer of learned advocates, the matter stands adjourned till 22/7/2025. That is just not today.
Yes, sir.
22nd.
22nd.
Vice Chair.
Item number 29, my lord, Mr. Shotru Banerjee is appearing for the defendant respondent, my lord.
Mr. Thakkar is appearing.
I appear, Lordship will remember that report is to come.
Mr. Thakkar is appearing.
Yes, and my lord, we have taken a inspection of the report. It shows, my lord, that my lord, it has not been as yet, my lord, no restoration is there.
Okay, let it be not today. Let it be done in his presence, Mr. Thakkar's presence.
Yes, my lord. Well, may it be, my lord, in that case, my lord, be fixed on some day. We have seen the report. There is no restoration. It can be finished off, my lord. I'll inform him. He's there.
Let us see the report.
Order which client has been affidavit.
That is
Application of consequences. Nothing else.
13 December 1990.
Or kindly sees the report of 13 December 1995. It will speak for itself. We have taken an inspection.
See the last report.
কারণটা পড়াও না হাতে অবস্থা না আরে চার্ট বানিয়ে দিতে হতো না তোকে লিস্ট আউট ডেট দিলি না আর কবে দিবি কবে 30 এটা আবার কি
One thing it is clarified regarding the rents, the directions with regard to deposit of rent from the month of May 69.
No, that is not important. Important is the suit was dismissed. It was never restored.
Question. The Assistant Registrar Cash Department has also submitted that the Cash Department was not informed about any order dated 6/12/1995. As mentioned, the order dated 26/6/2025, and hence the Cash Department is not in a position to ascertain the genuineness
Yes.
of the order dated 6/12/1995.
Exactly. Now, my lord, comes to very important. They have found out this in the report 13/12/1985. Minutes of 13/12/1985. This will clear all doubts. There is a direction of AO by 24/12/1985. 13/12/1985.
6th day of
কবে রেস্টোরেশন ডেট লেখ না এখানটায় লেখ আরে এখানেই লেখ না report, the report is there. We have taken inspection. Yes, my lord. Minutes of 13/12/1985 is there in the report. না না অনেকগুলো রিপোর্ট আছে অনেকগুলো পাঠিয়েছে
order dated 6th day of December.
Minutes has been provided by the registrar. We have taken 13/12/1985.
6th day of December 1985.
A handwritten, my lord, is there in the report. এটাই দেখো this is not this is the ledger. There is a minutes copy, my lord. My advocate on record has taken inspection from this honorable court pursuant to my lord's direction. এর মধ্যে আছে minutes is there in my lord's court. My advocate on record has taken
It's book.
Yes, my lord, the minutes has been annexed. It's handwritten.
It's book.
Handwritten. He has taken inspection from my lord's court. কবে নিয়েছো inspection? Date বলো. Last Friday he has taken from this court. কিরকম দেখতে ছিল হাতে লেখা it is handwritten
See,
দেখো
because you see, if here it is stated that So far, the cause list of 6/12/1995 is concerned, there was no bench of Honorable Justice Ajit Kumar Sengupta.
Now, my lord, sees 1312.
This is the 6/12/19.
No, not this, my lord. There is a handwritten note. Not this one. এইটা একটু দেখাবেন ফ্ল্যাগ মার্ক করে যেটা হ্যাঁ দিন এটা দিন করিয়ে দিয়েছে কি করবো ওরাতে কি করে হয়
My lord, may I assist your lordship?
But this is no longer there. I am surprised. Friday he has taken inspection. Then, my lord, this is because there was a direction there on 13/12/1985. Affidavit in opposition by 24/12/1985. Affidavit in reply by 11/1/9. It is there. Thank God.
Mr. Banerjee is saying court records are missing.
Yeah, I
After
was
taking
surprised.
inspection.
I am
Bit of a
surprised I
strange
got it.
allegation.
Let us not prejudice the court. Let us go by what is there. My lord,
Yes,
kindly
let us go by what is there.
handwritten at the bottom. Now, kindly seize, my lord. Their date of restoration in the pleadings kindly bears it 23/12/1985, which is impossible, as I said. 13/12/1985, direction given AO by 24/12/1985. Affidavit in reply by 11/1/1986, adjourned till 13/1/1986. Then, my lord, under what circumstances it is been, my lord, restored on 23/12/1985, and there is no order.
It's already 13th day of
December.
December 1985.
And the handwritten note I showed to my lord of the minutes. There, my lord, there.
This one.
Handwritten, yes. That is the original of the court. Now, my lord, if it is
AO by so and so year and adjourned till.
yes, then, my lord, how on 23rd December 1985 it is restored and there is no restoration order. Now, my lord, kindly sees my lord, what is.
Being has to be matter has to be restored if it is dismissed.
It has not been restored.
Yeah, first of all, let us see the dismissal order. Hereafter, the restoration.
Dismissal order, as I showed, my lord, that is there. But, my lord, let us take, my lord, that dismissal order is not there. So, what is their case? That they have filed a restoration?
How can that be possible? Without dismissal, there can
My lord, it is their case also that they have filed a restoration application. So, there is a dismissal which is admitted by them also. When, my lord, a restoration application has been filed, my lord, that has been given direction on 13/12/1985. So, how is it restored on 23rd? There is no order. Now, my lord, kindly sees the endorsement at the back of the, my lord, this plaint. That is very important.
Judge's name not under.
Very important. Without any judge's number or anything, there is a scribbling there. Kindly takes the plaint, the back of the plaint. I have taken inspection of that also. This is what they are relying upon.
I will show what I'm relying upon. Let
Yes.
Mr. Banerjee keep his powder dry. First, he comes to
don't
court
keep
with a
powder.
fabricate document.
My lord, I don't want to.
He makes up an order of court. He makes up a fabricated document,
Kindly takes the endorsement now, my lord. Kindly sees. Dictable.
manufactures an order of court.
6/12/85 dismissed.
So dismissal is recorded. Now, my lord, kindly sees 23/12/1985. He's saying that is been restored. Where is the recording of restoration? No judge's name, nothing is there. He's saying so much about the order, my lord, which has been given by this court. And, my lord, the internet also is showing so. My lord, now sees, my lord, there is no endorsement. And dismissal date is there. There is no endorsement for restoration. We have to go step by step. Where is the restoration? Then I'll show his locus, my lord, that he cannot restore also. But there is no restoration. Exactly.
Let us ascertain whether the suit is.
Exactly. I'm so grateful.
First of all, is dismissed and thereafter is
So,
restored.
my lord, it shows 6/12 it is been dismissed. They have filed a restoration, they admit.
The
There is
document
a-
annexed is
Showing
95. 95.
Yes, and they, my lord, showing directions of 1985.
AO and AR and adjourned in 13/1/1986. Where is the restoration?
AOAR, how can there be AOAR if their matter is already dismissed prior to that?
Exactly. Exactly. And this is what has come. My lord, none of us has prepared it. Report of the my lord of this honorable court. Lordship, that is why I showed.
Matter is dismissed. How is AOAR?
No, AOAR is in the restoration application. But the restoration has not taken place of the suit. And now, my lord,
AOAR is given.
yes. Now, my lord, these handwritings are not of ours, none of the parties. This has come from the department. Now, my lord, kindly see the back of the plate. There is no restoration of the plate of the suit.
Please, first of all, let us see. That means, okay.
That means, my lord, 23rd December, no restoration can take place.
24/12, okay. Date of dismissal, here it comes, we get is
6/12.
6/12, okay.
Yes, my lord. 13/12 is the direction, which is not quite normal. It can take place if it is dismissed on 6/12. Direction is of 24/12 for affidavit in opposition, 11/1/86 for affidavit in reply, adjourned till 13/1/1986. Now, my lord, how can it be restored on 23rd December 1985 when the direction for AOAR is on 24th, on 13th of December till 24th?
Yes, Mr. Thakkar.
Now, my lord, kindly, for that, my lord, kindly takes, my lord.
Let us ask.
No, no,
What is the
kindly takes
position first?
Let him
kindly
exhaust
takes
himself first.
Yes,
Let him.
kindly takes the plaint first. The back of the plaint, the endorsement. The endorsement, my lord. My lord, where is the endorsement for restoration? Or in the at the front of the plaint, my lord? Where is it? And most important, my lord, kindly records there is no minutes copy recording that the suit has been restored. No minutes copy. ওরা কি অ্যানেক্স করেছে? কি অ্যানেক্স করেছে? রেস্টোরেশনে কি এখানে আসে অ্যানেক্স করেছে?
May I have a look at the plaint once, please, my lord? Your lordship.
Even I want to look at it, my lord, because I am going by my instructions only. Exhibits. 55 dismissed.
Sequence টা ঠিক নেই।
ওটা কোথায় বলছিস কি লেখা আছে? ওই এটা কি এন্টার্ড তো? এন্টার্ড তো, এখানে তো রেস্টোরেশন কোথাও লেখা নেই এখানে। Now, my lord, once I inspect the plaint, I'll show.
There is also another endorsement that is 11/1/1986. That is on 13/12/1985.
Yes.
This is
what, my lord?
no, this is also an affidavit. Affidavit by one Gopal Prasad Moore. Here it is stated.
Not ours, my lord.
Order made, yes. Affidavit in reply by 11/1/1986.
Then, my lord, this, my lord, I'm so grateful. If the person is filing, my lord, this affidavit, my lord, 11/1/1986, then how can it be restored on 23/12/1985? And now, my lord, very important, I am grateful to my learned friend also. Kindly sees the endorsement 6/12/1985, dismissed Judge A.K. Sengupta. Signature. Kindly sees, my lord, dismissed Judge A.K. Sengupta. Now, my lord, kindly what they are relying on, with date 23rd December 1985, there is nothing, no endorsement of restoration, neither any judge's name. Kindly sees.
23/12/1985.
Yes. What is that? Entered. That word is entered in short form. That is not restored. And there is no judge's name. And there is no judge's name. No endorsement, no judge's name for restoration.
What does this indicate? That is the question.
My lord, as far as we can, kindly, my lord, ask for a report also on this. My lord, this does not spell out, my lord, restoration. At least it shows entered or something. Now, my lord, more importantly, I am grateful to what my lord is holding, my lord, in my lord's hand, the affidavit in reply. The affidavit in reply is dated, my lord, 11/1/1986.
8 January 1986.
Yes. Then, my lord, how can it be restored on 23rd December?
That means restoration applications were also hard on affidavits.
Never heard. No restoration has taken place. There is no order. What they are relying on for restoration is that endorsement, 23rd December.
But this matter, this affidavit in reply,
They have filed maybe, my lord, which is on record, but there is no hearing.
affidavit in reply to any interlocutory application.
So where is the order for restoration? What they are relying in the petition, my lord, is that endorsement entered 23/12. That endorsement is not of any honorable judge, or there is no order.
Can be ascertained from this.
Exactly. Let the department give one order where it has been restored. Otherwise, I have shown from the downloaded copy from the High Court's website, it shows that the case is dismissed. Stands dismissed.
Dismissed, date of dismissal?
Yes. Dekho. That even shows 1969. What is going on, God knows, my lord. That even shows 1969. So let us go by this record. Even this record, my learned friend has filed AO on 11/1/1986, which is in terms of the direction of 13/12/1985. Then where is the restoration order? There is no restoration order.
Yes, so for 6/12/1985, it is an admitted position. We have to accept this. Maybe if that is 1995, the department is unable to clarify that.
My lord, if Mr.
We have to discard that 1995. There were no
My lord,
judges.
may I just go one by one, if your lordship permits me, my lord?
First of all, let us accept the position that
Yes.
as per the record, it is stated that suits are dismissed for non-prosecution, no order as to cost. That is
6/12/1985.
My lord,
Yes, that
right,
we have to accept.
not 95.
No, 6/12/1985.
80. My lord, there is no order to this.
No.
There is an endorsement.
Endorsement.
Yeah, I'll yes, lord,
Yes.
my lord, your lordship is asking me, Mr. Banerjee should let me reply. He's had his turn.
I
He
will-
can
I
hold,
will-
let him complete, let him complete. No,
I'll
let him
just take
complete.
2 minutes.
Let him complete, my lord. Let him
Now
complete.
you see, we have to accept
Let him
this
complete.
date of dismissal.
Yes.
Hereafter, we have to proceed. So that is there, we have to accept that.
So, my lord, first thing is that, my lord, there has to be a restoration of the suit. There is nothing on record to show restoration of the suit. What they have, my lord, relied upon on the back sheet.
Let Mr. Thakkar justify
Correct.
that.
He can answer, my lord. Thereafter, my lord, if lordship accepts that to be a restoration that entered in, then call for the record, my lord. And then I'll say, my lord, now even, my lord, the person who has, my lord, filed this petition doesn't have a locus. That I'll argue, my lord, thereafter.
Great. Well, I'll argue, I'll meet whatever arguments he has. First, my lord, kindly have his affidavit in opposition once. Mr. Banerjee wants inquiry into a lot of things. Let us first start with an inquiry as to where this Mr. Banerjee's client gets an order of court which says, my Lord Justice Sengupta was a judge of this court in 1995. That should be the starting.
You see,
That should be, my lord, kindly, my lord, kindly.
that has to be discarded. You see, that can't be accepted.
So, my lord, that should be the
absurdity.
I follow that, my lord. But somebody has filed an order of court before your lordship. Your lordship will turn a blind eye to it. Kindly see. This is an order which he has disclosed on affidavit. Where does he get this order from? This should be the starting point of inquiry.
It is definitely the court will consider.
Yes. Now, my lord, may I satisfy your lordship's queries? I do not dispute the fact that on 6th of December 1985, the suit was dismissed. Now, my lord, in all the reports which have been presented by your lordship, before your lordship, the order of dismissal is not there. There is no order of dismissal. Yet, I agree that the suit was dismissed, and your lordship is also pleased to hold that the suit was dismissed. And why does your lordship hold that? That is because of an endorsement made in the plaint. Now, my lord, kindly bear in mind, this is the original side of the High Court which we are talking of. Orders were not made of dismissal. That is why otherwise there would be an order here. Like he has shown an order, manufactured order of 95, he could have manufactured an order of 85 also, but no order is made. Why is it not made? Because, my lord, it is endorsed on the plaint. Why is it endorsed on the plaint? Because the original side rules of our court provide for it. Kindly take the original side rules once. These rules are there since more than 100 years, and we go by these rules. We don't go by CPC when it comes to recording of orders. Order recording came only when my Lord Justice Sinha came to this court, and then daily order sheets came to be made. Before that, it was recorded as a judge's fiat. Clause 12 leave, I have taken clause 12 leave, presentation of plaint, it used to be recorded in the back, clause 12 leave granted. That is a judge's fiat that is endorsed. That is why, my Lord, there, the dismissal is recorded as a judge's fiat. Yes, your lordship sees that. And my lord, there is good authority for this. It's not that the department does it, or that is not the signature of my lord Justice Sengupta as his lordship then was. Mr. Banerjee may be aware of his signature. I am not, but that is certainly not his lordship's signature, because that was
his
an
signature.
start.
No, but then he should submit properly. I never said this is his signature.
Yes, you submitted this
No,
is his
I
signature.
never said. I said there
Very
is
well.
an endorsement.
Okay, very well,
There is
very
a
well.
difference
Please
between
take your
signature and
seat.
endorsement.
Please take your seat.
Please read the
Please say. There cannot be any signature of a judge. So, but that was the submission anyway. Now, my lord, all that the rules provide, kindly see the original side rules once, my lord, this is covered in the rules. This is just and what is why he raises all these arguments is because he's illegally occupying my property after his father, after his grand uncle has passed away. Yes, I will show. Yes, you'll get your chance. Don't worry. Chapter 16, kindly come to chapter 16. There is no provision, there's no order. Unfortunately, there's a provision in our rules. The department doesn't do anything without a provision. Kindly see chapter 16, rule 21A.
Yes.
And this was brought into the Gazette in 1975. So it was very much there when this suit was being dealt. A note of every order of the court or a judge in chambers on an application in which an advocate appears shall be made by the principal officer in attendance on the back sheet of the summons or notice of motion or plaint, specifying the date on which the order is made, as also, Mother, kindly see, briefly specifying the nature of the order, such as application allowed or application dismissed or application disposed of by order made. That is all that is required to be endorsed. Where? On the back sheet of the plaint. By whom? By an officer of court. So that is why the dismissal is recorded there, and that is why the restoration is also recorded there. That is the RESTD, 23rd December 1985. Mr. Banerjee wants to read it as entered. I read it as RESTD. Now, why this is restored, I'll tell your lordship. Why it is restored? There was an order made in the suit for deposit of occupation charges by the defendant. This suit is dismissed in 1985. Mr. Banerjee would have your lordship believe that it restored and never restored. Never dismissed and never restored. Now, the defendant in a suit which has been dismissed continues to pay deposit rent till 2023. Your lordship's department continues to accept rent till 2023. The original defendant passes away in sometime in 1998. Kindly see the cost title now, which is where it becomes very interesting. Whom Mr. Banerjee represents? Wait, no, Baba. Kindly see the plaint now. Since your lordship has the original papers, court of record, that is why we have all this, my lord. Otherwise, this would not have been found. Now, kindly see the plaint. How he is Ramendra Saha and Sons, a firm having its principal place of business at number 12 Armenian Street. Now, kindly see the written statement which is filed. This is the plaint. This is the plaint. Your lordship has seen the cost title. The defendant is Ramendra Saha and Sons, a firm having its principal place of business. Now, the written statement, my lord, is filed by one Ramendra Saha, claiming, Jai Krishna Saha. The written statement, if it is there, Judge Sahib ke? We have annexed the written statement also. At page, kindly have my petition once, please. Kindly have my petition, volume 1. Volume 1 of my petition. Volume 1 of my petition, kindly come to Annexure H. At page 125. This is the written statement Kindly see 125, where the written statement concludes and your lordship will see the verification. I, Sri Joy Krishna Saha, the proprietor of the defendant above named. So it's a sole proprietorship firm of one gentleman by the name of Joy Krishna Saha. Now kindly see the affidavit in opposition which is filed before your lordship. Kindly see the affidavit in opposition. Dated. Kindly have the affidavit in opposition.
K1.
Yes, please, my lord. Verified on 16 December 2024. Kindly have page 2.
Yes.
I, Dhillon Kumar Saha, son of so-and-so, kindly note the name also, my lord, son of late Bhupatri Krishna Saha, carrying on business under the name and style of Ramendra Saha and Sons. Kindly see paragraph 1. I am the one of the partners of the defendant firm. Kindly see, my lord. It's a sole proprietor.
Describe him in the plaint as a proprietorship
Proprietorship.
firm.
Yes, I have said it's
in your plaint.
as a firm proprietorship.
Proprietorship firm.
Yes, my lord, he's filed the written statement. Your lordship saw the written statement.
As per the plaintiff. He's
Yes,
a proprietorship.
yes. Now, my lord, that gentleman passed away. Now, kindly see how I came to learn of all this. That somebody else is now sitting over there. That gentleman passed away in 1989. No, nothing on merits. Please, yes, yes, please. I will.
All on merits. Then I will also.
Please sit.
make
Please take your
submission.
chair. Please take your
No,
chair. Please take your
It's
chair.
not important.
So,
but
my
it
lord,
has
now
not seen
Joy
judicial
Krishna
time
Saha.
also, my lord, spent on this.
Oh my, he is very concerned about
Yes, I
judicial
am.
time, of course. Now, my lord, Joy Krishna Saha was the sole defendant. He was the proprietor of the. Joy Krishna Saha has deposited rent in a dismissed suit till 1989.
When did this person die?
1989 is,
The rent
I'm
is
sorry,
deposited?
it's there. Rent is, your lordship will see the report. Kindly see my supplementary affidavit. He died on 26 September 1998, which I find from the supplementary affidavit thing. So, lot of inquiries have to be directed. Dead man impersonated by Mr. Banerjee's client, depositing rent in court.
Rent is being deposited in the name of the dead person, but according to you, this person died in 1989.
Yes, so 98. Till 1998, this person has deposited rent by the same advocate on record who's filed his written statement. So now Mr. Banerjee would want your lordship to believe that the defendant, represented by an advocate on record, has deposited rent in a disposed of suit and continued, and this defendant passed away in 1998. The suit was dismissed in 1985. For 13 long years, he has deposited rent in a disposed of suit, which the
Do one thing. The records are all here. Both of you. Yes, Mr. Banerjee.
Yes, sir.
So records are all here. Anyway, I've gone through the records. Again, I shall go through.
I will my lord,
Malad, there
answer all is.
Both of you come with
The written-
dates
yeah.
justifying your stand. on
Yes,
this issue.
yes, my lord. On the
Malad, two more.
maintainability.
May I just two more?
Yes.
The suit is dismissed. There will be a decree which is drawn up. It's a disposal. There's a disposal. There a decree is drawn up. There's an order which is made. The order is filed. It is drawn up and completed. So many times we come for leave before your lordship. There's a decree which is drawn up of dismissal.
For default.
Correct. Even then there's a decree. If it is not restored, there will be a decree.
Default.
Even the decree dismiss for default. All noises are here, but there is a dismissal.
Better you do one thing. Come with a list.
Yes,
of
my lord,
dates,
better.
your justification.
Yes.
He'll argue it.
Why or on what grounds you think that it is restored and this dismissal is not there regarding those rains and everything.
Yes.
Yes.
My lord, also my lord gives my lord a direction so that both parties can apply for a certified copy of all these my lord reports. We'll apply, my lord, both of us. Kindly gives direction. Now the water is out and we can see how crystal clear it is.
My lord, kindly give it next week. Then we'll come before your lordship, my lord, because this is pending
No,
for some time now.
certified copy won't come within next week.
So
We've already taken inspection.
you know the
Yes,
facts.
yes.
Yes,
He's
my lord.
taken inspection with.
You come with a list of
Yes.
Yes, my lord, kindly gives a direction at least for a certified copy.
terms of earlier order dated 26/6/2025. Submitted register original site. perused the said report, heard the learned advocate, expired without any perused the records of this case. As the present dispute raised by the learned advocates is with regard to the suit being earlier dismissed and not restored, and the suit earlier dismissed and subsequently restored, the learned advocates are granted opportunity to come with necessary list of dates and the relevant documents relied upon by them to justify their stand. The parties are granted liberty to apply for certified copy of the reports.
But kindly keep this matter next week, my lord, same day.
Let this matter appear on 24/7.
I won't be there.
Okay,
23rd?
29th.
23rd, 23rd, your lordship. Then 22nd.
That's why 29.
29. Great.
Your lordship takes it up only on those 2 days of the week.
Yes, yes, chamber matters is Tuesday and Thursday. 29th, sir.
Grateful, man.
Grateful one. Deep love life.
ये आपका है ना?
My application, my lord. I appear for the defendant number 1. This was
Yes, 7.
yes, my lord. This is an application, my lord, for amendment of the written statement, my lord.
No. It
Your
is
lordship,
fixed- Is it fixed for orders?
my lord,
The hearing is concluded in this matter.
possibly, my lord, the hearing was concluded, but if your lordship wants, I can repeat my submissions, my lord.
I think and for the plaintiff response. This was the last one.
Oh, this is due to appear. Okay.
Lord, if your lordship wants, I
Yes,
can
let this matter appear for orders on 18/7/2025 as earlier directed. So it will appear tomorrow for orders. Yes. This is my application for revocation of grant of probate. Now, in this matter, but you will recall that we applied for a handwriting expert. And so the documents were sent to the question department of the government. And the report came. On the report that is specifying this, saying that my client's signature, which is appearing in the so-called no objection certificate, is forged. The report now she will yeah. That's my specific case in my application for revocation. Now, if Lordship's pleasure to see the revocation, which is GA2. GA2, the will is at page 31. If I take your Lordship to the petition, yes. The will is at page 31 of my client's father, the document. Now the probate was granted, it was revoked now. Another certified copy was obtained. Yes, and page 30 is the alleged, this is the will. Page 30 is the alleged no objection certificate. This is only this 4 letters, 4 lines. Tapun Pal, attesting witness, and next para, we Ashalata, Meera Dash, Rita Kormokar, consent to the above prayers of the petition. I appear today for Meera Dash. Meena. It's Meena Dash. And this is the signature of Meena Dash, which is appearing the second signature. Meena Dash. So we question that this document, this signature is forged. This is not my signature. It's a manufactured signature. I must also indicate that there has been some time between the probate being granted and I making this application, because probate was granted in 1995. I made this application in 2021, but it's fraud on court. So the limitation per se won't apply, my lord. It's fraud which is being done on court. This is not my signature. When I said this, it was observation from the court. How do I say it is my signature? So for that purpose, I filed another application, which is GA3.
for sending the records to the handwriting expert, to the department. That was allowed. A report comes in. Now, Lordship will kindly see the report which comes in. Because nothing else will be important, minute, because the report which comes in from the report talada আছে certificate কপি নিয়েছি ওইটাতে হবে মানে রিপোর্টটা তো দেখে না এবার সামনেটাতে yes, this is the report, Malad. We obtain a certified copy of this report. Once this report comes in, Malad, this is from the Central Forensic Science Laboratory, Newtown. Now, second page, first page is the covering letter which comes to the registrar original site. The second page, Malad, this Justice Patanak's orders is recorded, and it is taken on a sealed cabinet. Description of the exhibit. The second page of the report. Yes, in the bottom. All documents in 41 sheets and 1 PAN card. Because we had produced our authentic documents. Or documents containing my authentic signature. My PAN card, my bank records and everything.
So for Meena Das is concerned.
Yes, only for Meena Das. Only for Meena Das. Yes. Take a report. This is a lay report before the court has been. Internal. This is receiving reply. That's a lay report.
Yes.
Yes. Now, all the documents in 41 sheets and 1 PAN card received from the following authority were encircled, stamped and marked in the laboratory for questioned documents as X, while in the standard document is A2 to A7, A7 by 1 and A7 by 12 and 18 by the following description of the document is mentioned in the forwarding letter. Now, the document X is the document which is the alleged no objection certificate. Now, the next page, madam, opinion. The document of this case has been carefully and thoroughly examined. The person who wrote the blue endorsed signature, stamped and marked A2 to A5, A7 by 1 to A whatever, did not write the red endorsed signature similarly stamped as marked as X. X is the document which is the forged document which I say, marked as X. Result. Results relate only to documents examined. After examination, the documents are in a sealed cover and the signature marked as A6 being scanned and reproduced, hence not considered for opinion. So only the opinion portion, the X marked signature is not my client's signature, which is this expert. And the next page, Lordship will kindly come. And he says why he comes to this conclusion. The reasonings. I have carefully and thoroughly examined the documents in this case in all respect, and the handwriting identification and detection of forgery with the scientific aids such as hand magnifier is stereo microscope available in the Government of India Laboratory, Kolkata. My opinion is that the person who wrote the blue endorsed signatures, stamped and marked A1 and this series, did not write the red endorsed signatures similarly stamped and marked as X, is based on fundamental differences in class and individual handwriting characteristics between the question document and the standard signatures. The standard signatures stamped and marked with the A series are written with smooth line, quality and gradation of pen pressure. These are consistent intersay in handwriting characteristics, show natural variation and suitable for examination. The questioned signature marked X differ with the standard signatures in handwriting, characteristics of skill, speed, overall size, proportion of letters, slant, rhythm, slow, drawn, execution, which are all act of imitation. They show fundamental differences with the standard signatures in the basic structure design of letters with movement characteristics such as manner of execution letter M in 2 pen operations along with curved commencement of shoulder part of X of it. Nature of simplification of the letter I, which is a minar, they said the next word I, body shaped of the letter A along with the nature and direction of its tampered finish as observed there and finished in the word Mina. The manner of execution of the letter D. So this is on the surname Dash. The D, which is the body shape of the letter A and the nature of its joining, manner of simplification of the letter S with curved body part along with the nature and direction of its finished words. So these are on these findings, my lord, and all the aforesaid differences are fundamental in nature and beyond the range of natural variation of writing. I do not find any characteristic similarities in the execution of the letters. Considering the fundamental differences without any characteristic similarities led me to the aforesaid opinion. So the reasons are over here. So on this, my lord, I say the document which is at page 30 of the petition, which is this my client's signature, the alleged signature, is not of my client. This is proved by a scientific expert. It is not my statement. Page 363.
These are also identified by the advocate.
No, this was identified by the court, my lord, because this is recorded in Justice. But
No, just below this.
Yes, identify. Yes, yes, oh, yes, 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 yes. I bow down to your lordship. Yes. So this signatures, I'm only on because my client is today is only on Mina Dash. So this the fundamental document on which the probate was granted, treating is to be a non-contentious matter, and the probate was granted. Is this the no objection certificate of my client? And today, my lord, the other sisters have died, but Ashalata is the mother. My mother, she has expired. Rita is also no more. So I'm the only daughter to the executor, the testator living. Now I say this signature is forged. A probate obtained. Now if we read the language of 263, my lord, the proceedings was proceeding to obtain the grant were defective in substance. The grant was obtained fraudulently by making false suggestion. So it's the suggestion given to the court that I have given my no objection certificate, and based on that, it tended to be a non-contentious matter and the probate was granted. Now, 263, explanation B. I am on explanation B, my lord, and it's also that grant was obtained by means of an untrue allegation of facts essential on the point of law to justify the grant.
260?
260. Yes, on that succession. Revocation. That's the only section. 263. So, and I should also point out in the supplementary affidavit, now, yes, now the opposition reply has been filed, because I'm not taking to the opposition reply because the report of the scientific expert is the main document which has to be looked into today, and that is not challenged. The scientific expert report is till date remains unchallenged. Now, I must also indicate, my lord, we then
on this, I would like to interject for a second. Yes, we haven't challenged the scientific expert opinion. Maybe we'll not, but the fact remains, lordship, that the council today could not arrive here because he is busy.
No, this is the fourth adjournment.
Yes,
this is
Yes, thank you.
Yes,
Obliged,
it's
lordship.
recorded in the last order. Then no further time will be granted. So that was this is the fourth then. Before the report came. Yes, they were all contesting hotly when the report came. The moment the report came, 3 change of counsels, change of advocate on record. It's recorded in my lord's order. Say 26th of June. The moment the matter coming, some difficulties. Yes, and now they are controlling the properties. They have sold many properties in the meantime. Because any event I cannot enjoy order of injunction because I came such late. Whatever. That is recorded. No further time will be granted in the last order. Now, my lord, today I must also indicate in the opposition to supplementary affidavit, they have filed a supplementary affidavit. After the opposition reply, a supplementary affidavit comes in. Other pleadings in the opposition and reply may not be germane in the light of the report of the scientific laboratory, my lord. This I should indicate, my lord. Now, yes, this is at page 6. Yes. There is one purported signature which is coming, my lord, with the supplementary affidavit of 1989. It records I, Meena Das, wife of Raja Dinendra Street, received from my brother Deepak Rai rupees 10,000 in cash, according to my father's late Shunil Rai's last will. Father, I declare I have no claim, or she will say some overwriting. Father word is whatever the English father. No, is father to the father.
No, have you disputed this?
Yes, I've disputed this.
This is not your signature.
Yes. Now, even for this document, trial has to be there to prove these documents.
After the document.
It is, yes, even for this, the original, who got this, even I have disputed this signature also on this revenue stamp. Even I have disputed this signature also. Now, the next page, another is, I'm not concerned with the next page document. This is not of my client. So far, this document is concerned, my lord, I have also disputed this in a further affidavit in reply that this is not my signature. Paragraph 7. I have disputed this also in paragraph 7. Yes. This is a reply to supplementary affidavit. I only am concerned with page 6 because I say this signature is also forged. This is not my signature. So, my lord, is a probate proceeding is a court of conscience. Now, today it's proved, Lordship will see these two signatures in the signature in the alleged NOC, the page 30 and page 6, if Lordship. Now, so far this document is concerned, I have said this is also forged. Now, whether this document in any event.
Variation. This signature and this signature is.
This is a variation
Of this.
Yes, but this document was not before the court when the probate was granted.
So this one.
Yes, this document was not before the court. Today, court, if I may humble submission, court cannot look into this document. I am only on the probate petition. Probate petition, the original petition is before the court. It can be department, the original probate petition test. That can be brought. That is the court record. Because we have taken inspection. I had taken inspection personally of the record because to ascertain. Now today this petition was not before the court. This page 6 when the probate was granted. So anything coming thereafter has to be on trial. Court cannot decide something that is true, authentic, original. But the original NOC is before the court. The alleged original NOC. The document on basis of which the probate was granted is before the court. Only that has to be looked into as on date. That is forged, fabricated, which is proved by the third-party expert, the government expert. So, in that view of the situation, Milord, I say, Milord, I've prayed for revocation. That Lordship will see the summons. Summons for the area. Lordship, the summons. The summon ta kore galo. Summon ta that's sorry, I must have misplaced the summons. I am armed with 2 judgments, my lord, because a serious point of limitation was taken in the affidavit in opposition. I will just also cite those decisions. I asked for revocation of this and liberty be given to me to contest the proceeding by filing caveat, affidavit in support of caveat, and it takes the turn of a testamentary suit, whatever it followed. I'll contest the matter. Now, you must also indicate, Milord, they have said that yes, this is the main point that I have to address. This probate was granted in the year 1995. And I come in 2024. 21. Revocation in 21 because this took some time. So it's all these years. So this has to be. Now, I fall back on the same principle of Article 137 that 3 years from the right to sue accrues. Because I had no knowledge because this entire thing was done behind my back by my signature taking forged. Then the question which I have to answer, Mala, how do I come to know? What is my knowledge? Or should kindly come to my petition. Because my right to sue accrues from the knowledge which I name.
Page?
Page. My Lordship will kindly give me 1 minute. Page 8, para. Page. What is good paper? Now, another thing, para page 7, page 8, my lord, I have stated this is not my signature, the signature is a pair. I'll read this, my lord. Just cause to the probate be annulled and revoked. The proceedings was obtained but defective in substance. The signature of the petition on the purported consent was forged and manufactured. No affidavit asset had been filed by the petitioner. The grant was obtained by fraud, by making false suggestion and concealing material facts of the case from the Honorable Court. The grant was obtained by means of untrue statement of facts essential in the point of law to justify the grant. Now, this is also very important, paragraph 18. Petitioner has also ascertained that till date, no inventory and accounts have been filed before this court in connection with the said grant. The connection with the said grant. So till date, this has been not been, but this is a duty of the executor to come before the court and file the grant. Now, paragraph 20. The petitioner had no knowledge whatsoever with regard to the grant. It is for the first time from the letter of 21st of April 2021, annexed herein above. I'll take you the letter. Issued by the advocate of Gita Rai, the contesting defendants now, the heir of late Deepak Rai, that the petitioner came to know about the existence of the said will and the grant. Since being aware of the grant, the petitioner has taken immediate steps for filing of the instant application, seeking revocation of the grant. The petitioner is 66 years of age and immediately after being aware of the grant had taken due steps for filing. There is no willful deliberate lashes on the part of the petitioner. Now, Lordship will kindly see the letter, which I say my source of my knowledge. Page 12 is my advocate's letter. This is my advocate's letter.
Yes.
This is my advocate's letter seeking partition. Now, see, we see the subject. I'm seeking partition to the estate of my father.
Yes.
So this is the letter I write. My advocate on record writes seeking partition. Now, what comes in reply? This is simplicity, a letter seeking partition. Page 14 is the letter by which my cause of action, I say, Malad. Here it says, this is from the defendant. Before dealing, yes, your client is very much aware that her father had made and published a will, which was duly probated by the Honorable High Court at Calcutta, recording PLA number such and such. The probate of the will was granted with consent and knowledge of your client. So this is a second assertion. In the circumstances, it is denied that Sunil Rai died intestate. The property of late Sunil Rai has devolved upon his only son Deepak Rai and he became the owner of all the properties left behind by his father under the probate granted in respect. Page 9, sorry. Page 9, para 24.
Yes. Okay, 13th December 1995.
95. Now, on fraud, Mala, it is well settled, Mala, amongst judgments.
96.
95, 96, 96. 95 লেখা আছে কেন আমাদেরটাতে? হ্যাঁ ঠিক আছে যা আছে বলছি ও বলছে 96
আপনাদেরই করতে
কোন প্যারা?
প্যারা 23 পেজ 12
না না এটা কোথায় বলছে আমাদের তো এইটা পিটিশন you should read GA2 now. তুমি GA3 দেখছো now. No, no, on fraud, which vitiates everything, and so that limitation will not be, because this long period. This is the long period. The two decisions on this, 2007 court Supreme Court case. আমার কপি আছে হ্যাঁ কপি নেই না এই আইপ্যাডে ছিল লিখে নাও 2007 volume 4 Supreme Court cases 221.
কপি দিয়ে দেবেন এখন আমি লিখে নিচ্ছি
2007 volume 4 SCC 221, 2008 volume 12 8 that 8 one I've handed over. Yes, and 2008 volume 12 SCC 481. My lordship, you can mark the paragraph numbers. In 2008, the para 26 and 27.
Okay.
Para 26 and 27, and the other one is 2007. This is para 21 to 26.
Para 21 to 26.
2007 is para 21 to 26. And 2008 is para 26 and 27. Sorry. I'm sorry, my lord. The difficulty is we don't have a copy, and sorry, my lord. I can place it because any event my learned friend will not submit today. I can place the decisions on the next day. Only for this purpose, placing these two decisions. But any event, yes, this is a তিনটে কোত্থেকে হয়ে গেল? ও আগে রেকর্ডে ছিল মনে এই জন্য আমার কপিটা চলে সরি দ্যাটস দ্য রিজন মাই কপি হ্যাজ গট ওকে we had submitted man any event so হ্যাঁ তাহলে লেখাটা দেখে দাও হ্যাঁ প্লিজ দ্যাট ইজ দ্য রিজন আই বিলিভ দ্যাট মাই কপি হ্যাজ গট সরি ম্যাম প্যারা এটা তো সাহেব লিখেছেন এই দেখে দাও we'll have a soft copy তাহলে দাও মানে I'll place these two on the next day because
on the next you can conclude.
Yes.
Submit on the next day.
Lordship will only beseeching because 3-4 adjournments has been taken. I have completed otherwise.
Mr. Mitro learned approval for the petitioner submits but could not conclude his arguments and shown till 24/7/35.
বেরিয়ে গেল 24/7 বুধবার বৃহস্পতিবার oblige
Yes. Well, this is my matter, my lord, where I was made a judgment debtor. On the last occasion, 8th May 2025, my lord had moved an application saying that there is no decree. So, my lord, your lordship, my lord, had
your application GA1.
It is yes, my lord, GA1. In that, a direction was passed by your lordship, my lord, where your lordship had directed them. Oh, my lord, there is a direction on the registrar, original side to submit a
file
clarifying the position as to whether, my lord, suit numbers 419 of 96 is still pending or whether a decree has been passed. And, my lord, the decree holder, that is, I believe he is appearing, my lord, was also given the liberty to file an affidavit in opposition.
My lord, to file the affidavit in opposition, we require 2 more weeks times, my lord, because
Affidavit to his Mr.
to GA1
application.
Yes, my lord.
Okay. Received the report. The register. For 7th July 2025. In terms of order dated 8/5/2025. Observed by the registrar original site that from page 54 of the affidavit filed in EC 129 of 2007, it appears that the learned subject 3 of Patna had been pleased to allow the prayer of subject 3 of Patna been pleased to allow the prayer of Dr. Ajoy Ram, the director of MS Blue Heavens Agro Industries Public Limited, the decree holder, and directed to transmit the decree dated 22/6/2000, passed in title suit number 419 of 1996 before the court of the civil judge, City Civil Court, Kolkata, for execution satisfaction of the decretal amount. Stop. It reveals from page 7 of the affidavit, and it raised the City Civil Court, Calcutta, was pleased to direct to return the papers in relation to this above mentioned suit to the learned record for the degree holder for presentation before the proper forum, as the same was not executable before the City Civil Court, Calcutta, for lack of pecuniary jurisdiction. Stop. As affidavit in opposition is filed to GA1 of 2025, let affidavit in opposition be filed by 31/7/2025, 31st July. Reply, if any, by 7th August 2025. Let this matter appear on 12/8/2025.
One humble submission, my lord. I'm sure your lordship had passed the order on the last division of the learned registrar to at least try and find that out. It's not that your lordship had directed the registrar to read the papers only. Because unless it is communicated with the Patna court, my lord, the registrar will all, well, there is no use relying on my learned friend's EC. That was not the scope of your lordship's order, my lord. If your lordship could kindly clarify.
Anyway, let him file the affidavit in opposition.
Because what I heard from your lordship, what felt from your lordship, my lord, he just, my lord, enumerated what is the case, and that is of no use, my lord. That was not the scope, my lord. I'm very grateful.
Your application should be based on certain facts.
Yes, my lord, the point.
Let him.
Yes, and the problem is, my lord, we have taken steps in Patna. My lord, it's being an old suit, my lord. My lord, it's very difficult to get any certified copies. My lord, it's worse than our state, my lord. I've understood that. So, well, that is the problem. So that's why we wanted that if it could be through the court. That
same difficulties been faced by us also, my lord. We have also applied, but due to the
that is the problem.
Let us see that.
Let us see what they file. Grateful, man.
My lord, my application, my lord, for seeking my lord an extension, my lord, time, my lord, to file the written statement. My lord, this, my lord, may file my reply, my lord. And what is appearing on the other side today?
Let it be not today.
Can it be on my lord 24th, my lord, in that event?
Okay. On the prayer of learned advocate for the applicant defendant, the matter stands at 24/7/2000.
I filed my reply, my lord. Affidavit in reply.
The affidavit in reply file be kept with the record.
Published, my lord.
For the respondent defendant number 6.
My lord, 34, I appear for the respondent number 6, your lordship. My lord, may I file our affidavit in opposition to the applications as filed by my learned friends? There are 5 applications. My lord, 34 to 39. My lord, only one thing, my lord, the respondent number 6 have died. My lord, this fact, my lord, I have, my lord, intimated before your lordship.
Now,
and
is before this court. GA12.
Yes, my lord, GA12, my lord, all the GAs, my lord, kindly take 34 to 39. My lord, analogous matter. These are the applications filed by the caveators for discharge of caveat. My lord, I am opposing that. My lord, I for the 6. My lord, only one thing. My lord, if your lordship kindly turns to your lordship's order, dated your lordship 10th of June 2025, your lordship will see that I have intimated this court that the respondent number 6 have expired. And my lord, respondent number 6 needs to be substituted. Accordingly, I have informed who will be substituted in place and state of the respondent number 6. My lord, I have given them a letter, my lord, on 1st of July 2025. My lord, till date, no steps have been taken, my lord, for substitution. So substitution has to be carried out first. Before, my lord, any more proceedings to be initiated, my lord.
File appropriate application
Learned advocates for the parties are present. As one of the which defendant died?
6, your lordship, 6.
Number 6 died, and necessary steps are to be taken for substitution of the heirs of the said defendant. The matter stands adjourned till 31/7/2025.
Lordship, item number 35, it is a GA13. Lordship, it is an application for substitution of the defendant number 2. Lordship may take up.
Which one? GA13?
GA13, yes, yes, Lordship.
Okay. With
Lordship.
regard to GA14. No, here also I think one of
Yes,
the.
Your Lordship, it is to be the GA6, the defendant number 6 is to be substituted. But Lordship, previously we have already taken out GA13 for the substitution of defendant number 2.
So with regard to save and accept this 35, other applications are to be adjourned, that is 14 and all this.
Yes,
things.
Your Lordship.
G, my lord, G 14, 16 and 17, and my lord, 15 as well, my lord. The applicant, my lord, file the application reply, my lord.
May I file the affidavit in opposition?
On behalf of?
On behalf of respondent number 6, I'm led by Mr. Mondol. GA 14 to GA 17.
Acha, the matter, acha, GA 14 of 2025, GA 15 of 2025, GA 16 of 2025, and GA 17 of 2025 stands adjourned till 31/7/2025 for taking necessary steps. Let the affidavit in opposition filed with regard to which application? GA opposition?
Well, all these applications, Your Lordship.
Let the affidavit in opposition which are
GA 14 to GA 17.
filed with regard to the applications GA 14 of 2025 to GA 17 of 2025 be kept with the record. Affidavit in reply may be filed after taking necessary steps for substitution. Yes, now this
GA 13 may be-
34.
Yes, Your Lordship.
GA
Item number
35.
34, GA 13.
Yeah,
GA 13, 2024. Item number 35.
and regarding GA 12,
Lordship, GA 12.
GA 15 সাথে একটা করে দেবে তো GA 12 টাও করে দেবে। Okay, this GA 13 is substitution
Yes,
application.
Your Lordship. Substitution of defendant number 2.
Dependent number?
2, Your Lordship.
Dependent number 2.
Yes, Your Lordship. And Lordship, I've also prayed for issuance of special citation upon the defendant number 1A, 1B, and 1C.
This is being contested. Any opposition is filed?
Yes,
Yes, Your Lordship.
Then it will take some time. Let it
yes, Your Lordship. Let all the matters be, my lord, heard analogously, Your Lordship.
Formal application for substitution only.
Where is the prayer for substitution? This one.
Lordship, prayer B.
Because there you see, they have filed their opposition also to your application.
Lordship, that is in
GA
respect of
13 you
GA
have filed your opposition.
Yes, yes, Your Lordship. Yes, we have.
Mr. Mondol, we have filed GA 14 to GA 17.
Oh, I'm sorry. I'm sorry. I'm sorry then.
Opposition filed. Yes, Your Lordship. GA 13 opposition is ready, but there was a direction to file opposition with regard to GA 14 to GA 17.
Yes, but 13 we have made it ready, so you can serve it and you can file it before the honorable court as well. Because there was a direction earlier, there was a direction for filing of the affidavit.
To do the application. Lordship, a copy may be served upon us. We shall come back.
GA 13
Lordship,
you
the
ready with
formal
the affidavit?
application.
আচ্ছা, তাহলে GA 13 এও আচ্ছা GA 13 এ অর্ডারটা করে লিখে নিন তো। GA 13 মানে item 35. Affidavit opposition to this application GA 13 of 2025 is being filed. Let it be kept with the record. Affidavit in reply may be filed. How soon can you file your reply? On or before 31st July 2025. Let this matter appear on 31st July 2025.
My lord, along with the other applications as well.
Others application.
Yes.
In the meantime, you take necessary steps for substitution.
Yes.
Since, my lord, these two are applications for substitution, my lord, it would be my lord pleasure to direct the affidavit in reply in GA 14 to 17 be filed after the substitution. My lord has fixed
Whatever is filed, let it be there, but these matters are to be taken up. This GA 13, that is item 35.
Yes,
that has to be taken up. Definitely on 31st, it will be taken up.
Yes, my lord. So shall I file my reply after that, my lord? Shall that be, my lord?
No, because they have used an affidavit with regard to GA 13.
Yes, my lord.
GA 13, they have used an affidavit to GA 13.
Yes, my lord.
So if they have used an affidavit to GA 13, so a reply has to be filed.
Yes, my lord.
Lordship will do the next.
13, I apologize.
Yes.
13 is only for substitution. There is no scope for any.
Because they have already
Without
filed
any
an opposition.
direction, madam.
No, there was a direction passed by my lord Justice Shogata Bhattacharya, Shogata Mojumdar.
It is only for substitution of one of the parties to a testimony proceeding. I don't know what objection my learned friend can have to that.
Probably they sought that leave with that was granted on the last occasion.
Well, it's a
Anyway, you did not oppose to that. On last occasion, it was granted.
I understand they've not served an advance copy. They're coming in, handing over a copy, my lord.
No, I'm sorry for that. But I thought it was also served because my lord directed us to serve to all the oppositions we have served. It's a fault on my part. I apologize for that.
GA 13 টা আছে এটা একটা order.
Only your lordship kindly makes a specific direction, my lord, for taking steps for substitution of the respondent number 6. Because lastly, on 10th of June, your lordship, there has been an order passed by your lordship for substitution. Till date, no steps have been taken, your lordship.
Anyway, let us see on that.
That we are taking.
Before my lord rises. Your lordship, before my lord rises, my lord, item number 1, my lord, of my lord's list, my lord, I appear for the joint special officers, my lord, the receivers. My lord, what has been done, my lord? Your lordship, by way of my lord's order dated 3rd July, had directed the receivers to execute the conveyance, the deed of conveyance. We are executing it. Now, my lord, one of the parties have filed an application for recalling, and my lord, that
Whatever it is, you come with necessary applications.
your lordship, my lord, I need not come with an application. I am just seeking, my lord, that my lord, I am complying with my lord's order, my lord. I shouldn't be faced with a threat of contempt, my lord, because I am complying with my lord's order. And my lord, someone has filed a recalling application, not moving that application. And my lord, there are persons coming and asking me to execute the deed.
Different issue. This matter is different. GA 282.
No, no, my
This is
lord.
for clarification of
That
earlier
was for
order.
clarification of earlier order, but my lord, this is, my lord, there is a threat of. Huh?
Mention upon notice to all the parties.
Lord, all the parties are present, Lord. All the parties are present.
On my application, it's already passed by your lordship.
Yes.
It was at his instance.
Proceeding of the court. Okay, on the next day.
Very well. Then, my lord, if my lord will.
Yes, yes. On the next day, it will be taken up. Yes.
Lord, will it be my lord's pleasure, Lord, to keep the matter on Lord, tomorrow under to be mentioned, so that Lord.
By notice will mention. There is a technical error also. But it's 15, 25.
What threat you have received? You have with any written intimation come with all these particulars.
Lord, no threat we have received, but Lord, we are not being allowed to proceed. I'm saying, Lord, that there is a threat of contempt because of the recalling application.
Come with the necessary application.
The receivers, my lord.
Whatever it is, parties shall also come with the parties may come with necessary
Then the
application.
plaintiff has to come up with an application.
The special officers. Now the directions were given by earlier Justice Banerjee.
Whatever it is, if you want some order, I have passed an order. I have passed an order earlier. If there are subsequent developments, you come with necessary application.
I think personally, I think there's nothing at all. It's my lord order is very clear.
It is not necessary if my lord passes.
My order is there. If there is subsequent development or problem, you come with necessary application.
The party who has filed an application, they ought to have taken the steps, but they are not taking any steps.
Anyway, whatever it is,
Lord, we just wish to signal that during the pendency of the application, we can proceed with the conveyance.
No, in this way, no orders can be passed.
Very well, my lord. We shall then.
Item 44 on the prayer of learned advocates, the matter stands adjourned till 24/7/2025.
I was praying, Lordship, that make if it is not possible, Lordship. My
Yes, item 58 and 59. Record an order. The prayer of learned advocates, the matter stands adjourned and fixed at 30 তারিখে দেখুন তো আছে কিনা কোনো 29-30 দুটোর সময় কিছু 28-29 29 তারিখ ফিক্সড আছে কিন্তু 2 PM নেই 2 PM আছে 30 তারিখে নেই 2 PM নেই আচ্ছা ঠিক আছে 2 PM নেই okay I'm keeping it on 30th at 2 PM. The matter stands adjourned till 30th July 2025 at 2 PM.
Your Lordship, may I please be permitted to mention one matter? My lord, this witness action was going on. The plaintiff's witness was being examined, but I'm only praying if this matter can be placed as to be mentioned, my lord, further.
When is the matter due to appear?
My lord, the matter is not due to appear. I'm praying for inclusion under the heading to be mentioned, my lord, so that.
Give the slip, it will appear as to be mentioned.
Yes, Your Lordship. Okay.
Yes, call the list.
To be mentioned, item number 46.
But wait, please, Your Lordship. This matter has come at the instance of the.
No,
this matter has come at the instance of the.
No, when the matter is due to appear.
Lord, it is due to appear 15th of August, 27th of July. But this has come up at the instance of the joint receivers for some clarifications.
Yes.
And on the last occasion, Your Lordship granted the joint receivers liberty to circulate some points for consideration and submit, my lord, our points before Your Lordship. My lord, may I?
Yes, that is there.
It has now, my lord, come back to Your Lordship. So this is in the form of a suggested order. If Your Lordship kindly sees. If Your Lordship, my lord, kindly sees paragraph 4. These are, my lord, the prayers which Your Lordship was pleased to grant by Your Lordship's order of June 19, 2025.
Yes.
That is, my lord, joint receivers and commissioners of partition be directed to cause publication of the notice of sale of the properties described in paragraph 15. And joint receivers of partition be directed to provide inspection of the properties. Now, my lord, if Your Lordship kindly sees paragraph 5. Lord, these are the clarifications which we are seeking one by one. Lord, if this forms a part of Your Lordship's order, then we would be much obliged and there would be.
So you want this in Hindi, it should be published in Dainik Jagran.
Yes, my lord.
And in English, which paper in English?
My lord, Your
Times of
Lordship,
India.
Times of India, because Times of India, my lord, has a national publication. It gets published from Delhi, which is circulated all throughout India. So we, my lord, want to publish in the national publication.
So this is Dainik Jagran is Hindi.
Yes, my lord, Dainik Jagran
And
is
local language, this Bhaskar, local language.
No, Dainik Jagran is Hindi for Uttar Pradesh. There are two sets of properties. One is in Uttar Pradesh, the other one, my lord, is in Rajasthan. So for Dainik Jagran, my lord, is for Uttar Pradesh to be published in Hindi vernacular. And Bhaskar, my lord, is in Rajasthan, also to be published in Hindi vernacular. And then, my lord, Times of India, we will be publishing it both for Rajasthan and Uttar Pradesh in English language, my lord.
The vernacular publication shall be made on 27.
2025, my lord, is the suitable date. If Your Lordship passes the order today, my lord, we can comfortably do that because the my lord, form of publication, we had shown it to the registrar.
20th July means within 3 days.
Yes, we will be in a position to do that, my lord, because the form is already before the registrar and the registrar has gone through it. Now, my lord, the next thing is, my lord, the publication must mention the date of inspection of the respective reserve price and proportionate earnest money in the following manner. Now, Your Lordship, my lord, there are 4 properties. We have, my lord, suggested the reserve
And
price.
Gopal Bagh is so and so.
My lord, this is where, my lord, I appearing for the plaintiff joint issues. Reserve price is where your lordship would kindly not permit the modification, because in connection with the properties in the same suit, this issue was there that reserve price fixation would ultimately reduce the price. My learned juniors are there in court, my lord, if that order could be handed up in this suit while selling of a property which the defaulting purchaser is standing in court today. My lord, there was a reserve price which was fixed, which was not fixed, and that was one of the points which one of the intending purchasers had sought to argue. That where upon considering judgments of the Honorable Supreme Court, it was held that the reserve price cannot be non-fixation of reserve price will at the end of the day would benefit, because the price won't be bogged down in that case. So, kindly do not consider the reserve price. Otherwise, we do not really join issues with the other proposals which the joint receivers are making. And also that one thing, serial number D at page 3 of the suggested order, that property, we are really not pressing for that at this stage. That is
BB.
No, D for Delhi, your lordship. D for Delhi in the 3rd page of the proposed order. D for Delhi.
Okay.
That is one more property.
That is Beldev Gang building.
Yes, yes. That we are not pressing as of now. Your lordship would kindly delete that from the order subject to my lordship.
So that can be kept in abeyance.
That can be kept in abeyance. Otherwise, my lord, we really don't join issues with the other portions of the suggestions which have been made.
Now, regarding inspection time, some more time should be granted. 11
as falls from your lordship, my lord.
11 a.m. to 1 a.m. Let it be some
Even
time.
if the reserve price, my lord, is not mentioned, we receivers, we have nothing to say. We'll only comply and follow your lordship's orders.
This inspection time be enhanced. That is 11 a.m. Let it be up to 3 p.m. or 4 p.m.
As your lordship pleases. So, my lord, the portion.
Kindly do not fix any reserve price for any of the properties. Your lordship has the valuation. The offers received would be put before your lordship for confirmation. If your lordship thinks it is shockingly low or anything else which would shock the conscience of the court, your lordship can always direct a re-auction. But my lord, fixation of reserve price would, at the end of the day, would attract a much lesser price, and people will not be, my lord, wanting to bid higher than the reserve price, and these issues might be there.
Yes. Anything else?
With regard to yesterday, I had made.
Mr. Shorka, that is a different application. Could this order be corrected, because you are not really concerned with this?
Normal way.
Yes, very good.
I have one more subject to make. We require police help.
I agree, my lord. I agree. That should be there.
When the inspection will be taking place with respect to these properties. And, my lord, we have most recently, there is a local person appointed by us who takes care of the properties on behalf of the parties. They, my lord, this person has informed us that the property, my lord, which is serial number B at page 2, last 2 lines, it goes up to the first 7 lines of page 3. This property, my lord, is already having some litigation.
My lord, your lordship need not be troubled with all these details. Your lordship will kindly put a police help clause, my lord, if the receivers
regarding this, because we
any
have
of the above.
And I wanted to disclose this information in front of the parties. Now, if your lordship wants us to proceed with this, we must most certainly will be.
Yes, record an order. Yes.
My lord, could I take your lordship's kind leave, my lord? Great.
So that you will do.
As is. It is there. It will be there in the terms of inspection.
learned advocate representing the receiver and learned advocate representing the parties, and the learned advocate representing an intending purchaser is present.
My lord, the intending purchaser is with respect to another property which was already.
The intending purchaser.
This is, my lord, a fresh sale which has not yet taken place.
Okay. Learned advocate for the receiver and learned advocates for the parties are present. But in terms of order dated 9, terms of order dated June 19, 2025, directing the joint receivers to take necessary steps for sale of the properties described in paragraph 15 of application GA 26 of 2015 and cause the sale, the learned joint receivers have sought necessary clarification and have submitted that they be permitted to make publication in Doinik Jagaran, which is a vernacular newspaper in the state of Uttar Pradesh, and Bhaskar, which is a vernacular newspaper in the state of Rajasthan. Stop. Such prayer is allowed. Learned receiver has also prayed for publication in the Times of India in both Uttar Pradesh as well as in Rajasthan. Such prayer is allowed, and learned receivers are permitted to make necessary publication in Doinik Jagaran, Bhaskar, as well as in Times of India.
Lord, maybe your lordship, Lord, has correctly indicated 20th may be a very close day. Your lordship can keep it, give us 3 to 4 days extra so that we can do it. 25th or 26th, Lord,
Learned receiver has also further suggested that the time of inspection in presence of the joint receivers and commissioners on 24/7/2025.
Well, that is for publication, not inspection.
No. Shall be
vernacular
okay.
public.
No. This is for inspection.
No, my lord.
Intending in the presence of joint receivers shall be inspected by the intending purchasers. The publication, okay. Land, so and so land, you are given an inspection time. So and so land, you have given inspection time. Okay.
If your lordship is at page 2, I hope, my lord.
Yes, page 2.
So, my lord, page 2, Roman IV, if that is what your lordship is seeing, it is vernacular publication notices.
No, that is there. Come to 6A and B.
Yes, my lord, 6A and yes. This my lord, automatically gets extended.
Yes. With regard to fixing time for inspection by the intending purchasers, which is fixed on 24/7/2025, that may be made on 26/7/2025. Now they will be getting a very short time.
Lordship will keep it.
21 publication, 26 there's a very
Lordship
short
will
time.
then make it 30th.
On 30/7/2025. Yes. With regard to land at Aryanagar, Maharashi Dayanand Marg, Gully number 2, the inspection may be made on 31/7/2025. And with regard to the land and structure at 54 Old Station Road, Tej Mandi, Alwa Town, District Alwa, Rajasthan, pin code C01001, may be inspected on 1/8/2025.
One more day because they have to travel from Uttar Pradesh.
3/8/2025. As learned advocate for the plaintiff submits that they are not at present ready and willing to go ahead with the sale of the land and structure at Beldev Gang, building number 1864, Koshikalan, District Mathura, Uttar Pradesh, pin code 281403. the same sale of the property be kept in abeyance, and the learned receivers shall not proceed with the sale of the said property. The fourth one, D. Reserve prices for the said property need not be fixed, and the date of publication shall be on or before okay 23/7, on or before 23/7. Better they make it 23/7. Date of publication shall be 23/7/2025.
Not one humble request. Not with respect to the property at Alwar, Rajasthan, the receivers will not suggest that rather than it being 3rd, it can also be on 2nd. On 2nd of August. The Lordship has directed that the inspection
more time so that
because they will again come back, Milord. From Uttar Pradesh, they are going to complete the job start it on 30th, 31st, and then on 2nd they will do and come back. Otherwise, they have to overstay.
যেটা 2 তারিখ করা হয়েছিল না সেকেন্ড আগস্ট মানে 3 তারিখ করা হচ্ছে ওটাকে 2 তারিখ করে দিন।
Yes.
In view of the above observations, the matter stands adjourned till when is the matter due to appear?
No, it was due to appear on 27th of July.
The matter stands adjourned till 21/8/2025 for report of the receiver.
Milord will kindly consider paragraph 6 of the suggested order.
আরেকটা লাইন লিখে
The paragraph has a blank. How can you
just a minute. In the event there is any obstruction in conducting the sale, necessary police help may be obtained by the receiver. Yes, regarding 6. From when they are discharging the function? No, last when?
At least 2.5 years.
Huh? No, last remuneration received when?
Last remuneration was received with respect to Milord, the property for which Mr. Shorkar is making his submission. Another property, separate property.
Fast work throughout India.
Yep, practicing advocates.
But they are to discharge the function. You see, you appreciate their task also. You see.
Decide on the next day, but perhaps, Milord, I can, Milord, come in, Milord, over here, because, Milord, with respect to...
Anyway, let the receivers shall be entitled to a further remuneration of 2,000 GMs each.
And Milord, the cost and expenses will be borne by the...
That is implied.
Let that be borne by the party.
Yes, that is implied.
Yes.
Now, if your Lordship kindly considers, Milord, order, Milord, of June 12, 2025, your Lordship had directed, Milord, that, Milord, I am for, Milord, one of the intending purchaser of, Milord, a property in Alwar, Rajasthan, which your Lordship had directed for, Milord, to proceed with sale, Milord, in GA 18 of 2022. Your Lordship had passed orders.
Now,
But thereafter, your
this
Lordship...
application,
Yes,
in this application, there is no such order.
No, in this application, no such order has been passed.
So that application is fixed when?
No, that GA 18 was fixed on. No date was fixed. Your Lordship had directed to come back with an affidavit saying that when can I purchase the property.
So
I have yes, I have not brought the affidavit. Your Lordship kindly considers this.
This is not appearing today also, that GA.
But your Lordship had directed this because I'll tell your Lordship why. Milord, we were out of time initially to deposit the...
So let us do one thing, okay?
Very well.
Let this, what is that GA number?
GA 18 of 2022.
Okay, let GA 18 of 2022 also appear on the next date fixed, which is 21/8/2025.
would it be your lordship's pleasure to, my lord, keep this affidavit on record?
It's better, this matter is not appearing in the
Very well.
list, you file it on that day.
But, my lord, the difficulty is that,
GA 18 or 2020.
because, my lord, only difficulty is that, my lord, GA 18 of 2022, my lord, where your lordship had passed an order, your lordship had, my lord, extended the time to, my lord, put in the money. For putting in the money. Now, my lord, I want further extension. And, my lord, my time would lapse, my lord, in the meantime to put in the money.
Then you have to come with another application, you see.
That is the difficulty, my lord, which is why I'm not praying before your
Because
lordship.
this matter is not here in the list.
Your lordship can keep it, my lord, not in August, then, my lord, any day, my lord, next week, my lord, G80.
It's better, okay. Then
Any day
let-
next week, my lord, I'll come
let,
back with you.
let this matter appear in the usual courts on 21st. If you want this, your matter to be included, you mention it on any day. It will be included on any day.
Your lordship kindly, my lord, directs, my lord, G18 to, my lord, come.
I have directed, you see, on 21st, this GA will appear on the next date fixed.
The
On 21st August, this matter will appear.
My lord, the difficulty is that, my lord, the time.
You renew your prayer on that day, it will be considered. Definitely, it will be considered.
Then I leave it to you, lord. I am grateful.
Item number 47.
Seven. Yes, anybody is appearing? Not today.
Item 48.
48, my lord, in this matter, the defendant had put its witness and has been cross-examined. The last witness he wanted to bring, and number of days adjournment was taken on different dates on the ground of his illness. So finally, your lordship directed this evidence may be taken by way of commission.
Yes, yes.
Now I understand that commission has himself has not taken any step, although he has not given any notice to the commissioner. My advocate had given a notice to the commissioner. Anyway, now I understand that although his witness had not come to court because of his illness, now he is traveling Kashmir and roaming around there.
My client is roaming, witness is not roaming.
The witness can watch him. So, my lord, now he wants.
Later, you see.
Now, my lord, now he is witness, now he is ready to come to court. And he is suggesting, and I am also suggesting, subject to your lordship's acceptance, on 28th of July. My lord, kindly fix a date.
Any day of that.
Yes, I am coming to that. Now, my lord, now he is in a position to come to court in order to avoid unnecessary cost on the part of my learned friend. If your lordships kindly fix a date in.
Or let it be over, because once appointment is made, it is better to be over.
Very well.
Avoid any.
Lord, I am not also disturbing that. Let the commission be complete.
So I am just fixing a date for the commission work to be completed.
No, not only that, my lord, also kindly fix a date when the witness will be there. Otherwise, my lord, again, there will be a delay.
In the week of 28th July onwards, he is available.
So let commissioner.
Intimate the commissioner.
না ও আপনাকে নোটিশ দিয়ে দেবে কবে কবে available
Yes,
আছে?
record an order. Learned advocates for the parties and learned commissioner appointed in this matter is present. As the deposition of the defendant's witness could not be taken till date, the time stands extended till 11/8/2025. The depositions of the said witness must be completed in the meantime. Let this matter appear on 13/8/2025.
I'm not let the commissioner, my lord, fix a date, my lord.
So learned commissioner is requested to fix a date of this commission by upon notice to both the parties and their learned advocates.
I'm not party advocate. Otherwise, they to serve notice.
Acha, learned commissioner is requested to serve notice. Learned commissioner is requested to fix a date by intimating notice to learned advocates for both the parties. That what?
Item 49.
May please your lordship. Lord, item 49 and 50 are connected matters, my lord. 49, I'm appearing on behalf of the petitioner. It's an application for revocation of grant of probate. These matters were supposed to be taken up, I think, last week. It was fixed. I think a date can be fixed then, my lord, subject to your lordship's convenience.
So it was fixed on 10/7.
Yes, my lord, at 3 p.m.
So let it be fixed on some other date.
My lord.
Yes, item 49
and 50.
Item 50.
49 and 50 both together, my lord.
49 and 50. At the suggestion of the learned advocates for the parties, the matter be fixed on
22nd, my lord, subject to your lordship's convenience.
No, I'm fixing the matter. I have to see whether other matters are fixed or not.
Absolutely.
আচ্ছা, কবে 30 তারিখ আছে না 31 তারিখে আছে? তারিখে। আচ্ছা, 31 তারিখে নেই তাহলে।
Could it be in the first week of August?
I can keep it on.
Because till 31st, I see your lordship.
Instead of 31st.
Instead of 31st.
4 তারিখে দেখুন তো, 4 তারিখে তো কিছু ফিক্স নেই। Okay, 4/8/2025. No, this is hearing of the application.
Yes, the two applications.
4/8/2025 at 2 p.m.
My lord.
I can do that, no problem. But you see, sometimes there is uncertainty.
Yes.
3 p.m.
Yes.
Okay, 3 p.m.
Very well.
Anyway, I fixed it on 4th of August at 3 p.m.
Most grateful, my lord.
Item 51. Application for judgment upon revocation. Mr. Thakur.
Okay, this was fixed on 10/7.
Yes, but the respondent
at 2 p.m. So let it be fixed on another date. You are appearing,
they were
representing the defendants.
Oh,
So it was earlier fixed on 10/7. So anyway, your junior was there, probably Mr. Bagos.
Yes, Mr. Bagh was there. They were to file the written notes.
Ultimately,
May I make some argument and thereafter I will.
no, Mr. Bagh concluded.
He concluded, I'm told, and that is why we were to file written notes today. That was the last day's order.
Are you to reply?
I am to reply. He was to conclude and file the written notes, and I was to reply. That is the order.
But my learned junior perhaps have made submissions.
Yes.
Before the notes of submissions are being filed before your lordship, my lord, I want to make a submission. Maybe any other date, lordship, please, I don't mind. But lordship, kindly allow me to make.
No, I'm fixing the matter. That is why
Well, if my learned senior wants to do, he can do it today, my lord. We are ready because our notes of argument is also ready.
Because you see, I have so many matters today. Okay.
My lord,
So that is why I'm fixing it on another date.
very well.
My lord, kindly do.
Yes, record and order. Learned advocates for the parties are present. At the suggestion of the learned advocates, the matter be fixed on
Senior आया क्या बोल सकते?
আচ্ছা 30 তারিখে কি দুটোর সময় কোনো ম্যাটার আছে 30 তারিখে 31 তারিখে 30 তারিখে দুটো থেকে 31 তারিখে
Any day next week if it commences.
huh? No, I have no problem to keep it. I'm fixing the matter at a particular time. That is why I have to select the dates. আচ্ছা 31 তারিখে নেই বললেন দুটোর সময় Okay, 31/7/2025 at 2 p.m. So conclude your submission on that day.
The notes should be exchanged, my lord. That is your lordship's order on the last date.
Actually, anyway, that
Complete my submission.
because your learned friend will also submit written notes. That is why. And if your learned friend concludes, no, if your learned friend concludes, you try to give the reply on
Yes,
that.
yes, I'll give the reply on the same.
Pendings in November, 30th November, 6 months they took to file AO. Now
Sir,
they changed the.
now sir is there.
Does not go into that today.
Now sir is there. He assures that he will conclude.
We have the watch of the.
Yes, now I think now the needful will be done
Yes.
for you.
Sir is there. We'll grateful.
Part number 52.
Lord, this is a matter Lord I had mentioned. Lord, this was settled before the Lordship. Not all parties and advocates have signed. My Lord, this was. My Lord, your Lordship, this was a suit for street performance, my Lord, which was settled before your Lordship. And my Lord, time limit was fixed, my Lord, for not concluding the execution of conveyance. My Lord, the parties not have agreed not for extension.
With this thing, plaintiffs and defendant number 1 and
Yes, my Lord. No degree against defendant number 3.
so that has to be dismissed. So, but
That has
defendant
already been
number 3 is
dismissed. That's all.
concerned.
Your Lordship has already dismissed that. No, this is not a modification of the terms. My Lord, the suit was not decreed on the basis of the terms of settlement, my Lord, which provided for execution of conveyance within a time frame. Now that time frame note is being extended apart not from one minor modification. But that is what is being done by this terms of settlement. And all parties not who were signatory to the terms have signed.
31st August.
Yes, my Lord, that is it. So, Lord, should we please to pass it, my Lord, a modified decree note as per the terms of settlement.
Yes, record and order. Learned advocate for the plaintiff and learned advocate for the defendant number 1 and defendant number 1 and 2 are present. Are learned advocates. The parties have filed a revised terms of settlement. Peruse the revised terms of settlement entered into between plaintiff and defendant number 1 and 2. Upon perusing the terms of settlement, this court is of the view that the same should be allowed and the time to complete the execution of deed of conveyance mentioned in clause 4 of the earlier terms of settlement.
Your Lordship, will be pleased to pass not the order in accordance with the terms, because the other terms also not pleased to pass not a decree and order in accordance with the terms of settlement.
Earlier on the earlier terms, decree was passed.
Yes, no, decree was passed, and that is being modified not by this. Yes,
Time to complete the execution deed of conveyance is as per the earlier terms is allowed and modified. Let there be an order in accordance with the revised terms of settlement dated 16th day of July 2025 entered into between the plaintiff and the defendant number 1 and defendant number 2. Let
the decree not be drawn up not as modified.
The decree be drawn up accordingly
as modified. Yes,
and let the earlier decree passed be modified accordingly.
Yes, no, the certified copy has not been issued, so they'll be not yet been drawn up. So there's
I'm just
so,
stated that
yes,
let it be
there's no difficulty.
drawn up.
It's not been drawn up. If we checked up, it's not been drawn up.
Part of the deal.
Let the revised terms of settlement be part of the decree.
I'm grateful.
Dispose. তিনটের সময় একটু পরে এটা হয়ে যাক, এইগুলো হয়ে যাক আর কি।
Item number 54.
এদিকে আসবো কাউদি আঙুলি তো হ্যাঁ না 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 তার আগে আঙুলিতে ডাকলো না তো 53 ডাকুনি 54 আইটেম আগেগুলো তো লেখা ছিল 54 মানে my execution application lordship had passed an order 54 yes on 1st of July order in the first day when I moved on notice. Now there was an injunction restraining the judgment debtor from operating his bank accounts. Lordship will kindly see the order of 1st of July 2025. It linked with the PAN number. Now here there is one typographical error which has gone in. The PAN number is AACCA is 2121P. So it has the font is 1. Now it has known as I. So it is 2121. So that typo error has gone in because of the font. I don't know where it is.
এটাই PAN number.
No. It has to be last is the numerical always. In our PAN numbers, the alphabet is the last one is the alphabet. So there is no
P is the alphabet.
P is the alphabet. So there is not an I, it has to be 1. It has gone in Roman, whatever. It's gone in as Roman 1,
Yes.
whatever we call it. So that with this one is the this correction has to be done.
The
madam, only
parties are present. Learned advocate submits that in order dated July 1, 2025, there is a typographical mistake in paragraph 7 of the order. Stop. Instead of PAN AACCA 2122IP, it ought to be AACCA 2121P. Stop. Let the rectification be made. Other contents of the order dated July 1, 2025 remain unaltered.
IFA for the judgment data is a changed brief. I'm seeking leave to file the wakalatnama within the course
When
of
is the next date fixed?
29th
the 18th, today is the last day, no opposition has been used.
It's a changed brief.
29th
There is
is
a
the
change in
date.
circumstances. 29th, Malad, is the next date. Malad, Lordship will kindly extend the time for filing the opposition as was directed by the last order, and Malad kindly grants me leave to file my wakalatnama within the course of this week.
Okay.
Or by Monday.
Let
By
the
Monday.
time to file affidavit in opposition stands extended till
1 week.
Lordship will kindly give me more than 1 week. It's a changed brief. We have to go through all the papers. Lordship will kindly give me instead of 1 week,
till
Malad, 2 weeks.
29/7/2025.
29 July.
No,
That is-
we are not enjoying any interim order. That is the thing.
That is the interim order.
No, this interim order, Malad, I don't know whether
is the interim
money in the bank account or not because
That is the
there is
interim
no
order sought
direction.
for.
There is
No. There is
direction
the
to-
restant order.
Yes, that's
You have
the
to,
interim
you have
order.
some
direction to
section.
dispose assets. That is the only
That
thing.
one,
That will be done. Let him file.
There is
Well,
no direction
kindly,
to
while
disclose
kindly
assets.
gives me till the 2nd or 3rd of August, we'll file it.
And it is due to appear on 29th.
29th, but we'll change
Tell
it.
your power also in the
But
meantime.
I'm also seeking leave to file the wakalatnama with the department. Lordship will give me some time till Monday or Tuesday. I'll file my wakalatnama.
Matter
since
may
there is
appear
a
on
change in-
29th. In the meantime,
Matter
opposition
may
may come.
appear. Matter may appear, I'm only seeking some extension because there's a change in circumstances.
So by 29th, you cannot file your opposition.
But I
12 days.
But even then, Malad, they'll have to file a reply.
No,
Malad, even
let the opposition come first. Then we can come and press the court. The
instead of
opposition has come.
29th, Malad, I'm only seeking instead of 29th, may it be on 2nd or 3rd.
Okay, time to file affidavit in opposition stands extended till 2nd August 2025.
August is a Saturday, man.
Yes, working
Malad,
Saturday.
Working Saturday. Yes.
2nd August 2025. Reply if any by 6th August 2025.
My lord.
Let this matter appear on 7/8/2025.
Lovely.
The Vokalatnama may be filed
But by next Tuesday, Malad.
On
Coming
behalf of the
Tuesday.
judgment
Coming Tuesday.
by the judgment data by 23/7/2025.
Grateful, Malad. Grateful.
Item number 55.
রিপোর্টটা দিন তো একবার। Yes, Mr. Lahiri, I have perused the report and it says that no substitution application was filed.
No substitution has happened.
Yes, no substitution has been made in the place. The death of defendant number 5, namely Amar Kumar Mollik, has not been recorded.
Yes.
And no substitution has been made in his place. So let your matter appear for orders. I shall pass necessary orders on that application.
But we have on details, we have filed our opposition, everything is
Yes,
there.
yes, everything is there.
So, my lord, substitution application may be disposed of.
Yes, yes.
Not
Orders,
today, I am keeping it on some other day for passing orders. Yes, record an order. Learned advocates for the parties are present. Let this application GA 10 of 2024 appear for orders on 25/7/2025.
Acha, okay.
Item number 56.
রেকর্ডটা পাঠিয়ে দেবেন, ঠিক আছে? হ্যাঁ হ্যাঁ। Yes, item 56.
My lord, I am appearing for the respondent number 1.
Yes, what is this matter? Who is the applicant?
I am for the respondent number 1, my lord.
Applicant. Whose
No, my lord,
application
I am
is
not the applicant. I am not the applicant, my lord. My lord, the is related
No,
to
you are
this matter,
representative.
my lord.
You appear for these matters.
Yes, my lord. So, copy to me. My lord, the one property was auctioned, my lord. Auction sale was happening, my lord. The fund has been disbursed, my lord. After that, this application is the 56 and 57. Both are the similar kind of application filed by the different beneficiaries. The applications are pending, my lord. The fund has been disbursed, my lord. I am carrying the fund certificate also.
The beneficiaries are not here before this court.
Yes, my lord.
So let me fix some other day. Yes. Learned advocate for the respondent is present. None appears to move this application. The matter stands adjourned till 37/2025 under the same heading.
My lord, kindly fix it after 2nd August, my lord, because other matters relating to this property, my lord, is fixed on 2nd August, my lord.
Okay, let matter appear on 6/8/2025. Learned advocate is requested to intimate the other side by notice. '57 also same order. 56 and 57 same order.
Item number 60.
58. 58 হয়ে গেছে? Oh,
I'm the administrator in this matter.
yes, yes, I have heard this matter probably.
Yes, Lordship. Lordship, only difficulty is on the last occasion, Lordship directed me to come up with a formal application for discharge.
Because of some personal difficulty, I could not file that application. I'll do it within this week. If your lordship may gives me some time so that I can file and mention and come back.
Yes, record and order. Learned administrator is present and prays for time to file necessary application for the purpose of discharge. Such prayer is allowed. Let this matter appear on. How much time do you require?
Keeps it on 31st of July or 29th of July.
Okay, 37. 30 ছেড়ে দিন 31/7/2025 31st of July.
31st.
Item number 61.
Lordship, in this matter, I am appearing on behalf of the applicant. Lordship, I am praying for 2 weeks of extension for filing affidavit in opposition.
Okay.
Lordship, I am appearing for respondent number 5.
So whose application is this? GA13?
GA13, Lordship.
Your application. So in you have who wants to file affidavit in opposition?
Applicant, my lord. For filing on the joint receiver. Joint exception of the receiver.
No,
Joint receiver filing the
GA13 is
exception.
your application. So affidavit in opposition is required to be filed.
Yes, Lordship.
I
In
am
the
not.
last order, Lordship.
Mr. Shardar Amnidal is appearing for the respondent number 5, Manacha. We are not.
Yes, Mr. Ali is sick. Yes, item 61, record and order.
I am not objecting, Manoj, to that.
Learned advocate for the petitioner is present. On the prayer of learned advocate, the matter stands adjourned till 30th of July. 30th of July 2025.
August, my lord.
Okay. 4th August 2025.
Item number 62.
Applicant, my lord.
62, my lord,
I
I'm appearing on behalf of the legal
required
right
one
of the
more.
defendant number 2. I have filed my opposition accordingly.
Yes, my lord, I got it.
Let me see that.
Time is required for filing the reply. That is ready, but affirmation is not ready, my lord.
So come next week. I'm keeping it next week.
Next, my lord.
Okay, not this week.
Not this week.
Any date, my lord? No.
It will appear next week.
Next week.
Not 21, after 21.
Yes.
21st July, some position may not be.
Anyway, if there is difficulty on the following day, it will be taken up.
The time of file reply has already been expired, my lord. On 16 July, the time has already been expired.
Acha, record korun to. Learned advocates for the parties are present. The time to file affidavit in reply in GA to 2 of 2024 is extended till 22/7/2025. Let this matter appear on 23/7/2025.
23?
Item number 63.
My lord, in this matter, I appear for the plaintiff. My lord, this matter was fixed for filing of the report, valuer's report, in response to the exceptions taken in the earlier report filed by the valuer. So, I believe he has some difficulty.
My lord.
So some time may be allowed
Your lordship,
in that for filing the report by the.
No, my lord, I had mentioned this matter, my lord, yesterday, because valuer had written a letter to us.
Oh,
that
he had some difficulties.
Yes, he has some difficulty today.
Anyway, I'm
Personal
keeping it on some other day.
Yes, my lord, kindly after 22nd, my lord, any day, my lord.
Learned advocates for the parties are present. As the presence of the valuer is necessary, but he could not make himself present due to some difficulties, the matter stands adjourned till. আচ্ছা 30 তারিখে দেখুন তো ওই 3টের সময় কি 4টের সময় কোনো ফিক্সড আছে কিনা 30 তারিখে 4টের সময় আর 3টের সময় 4টের সময় 31 তারিখে 4টের সময় নেই Okay, 31/7/2025 at 4 p.m.
My
31.
31st July.
31st July 2025 at 4 p.m.
Great.
Grateful. Make himself present due to some difficulties.
Item number 64.
My lord, in this suit for partition, I have made an application on behalf of defendant number 3 for leave to, my lord, represent the estate of the deceased defendant number 1. Now, my lord, I find from the application, which is IAGA number 32, my lord, that there are defects there. I need to carry out substitution, my lord, in the cause title as well. I need to reaffirm and verify the written statement also, which was filed on behalf of the defendant number 1. So I'm seeking, my lord, leave to withdraw this application with liberty to file afresh.
I'm appearing on behalf of plaintiff. my
GA
lord.
32.
IAGA number 32, my lord.
And I'm appearing on behalf of plaintiff. In this matter, the documents, everything has been done. Only the hearing of the suit is pending. Kindly fix any date for here. Because, my lord, in respect of their application, I have no objection. I want the suit should be heard because I am interested only myself. There is a so 2 brothers, 1 sister, and mother's, my lord. The sister is claiming the mother's share. I have no objection on that. I only interested my share, my lord. Kindly heard the suit, my lord, because suit is pending from
I wouldn't stand in the way, my lord, but the suit needs to be regularized. Defendant number 1 has died.
Okay.
First and expunged.
First, the defendant number 3 needs to come on board insofar as the estate of the defendant number 1 is concerned, and thereafter, whichever way the suit will proceed, of course, will proceed. So, Malad, these are the irregularities which needs to be fixed out.
Learned advocate representing the applicant defendant number 2.
Defendant number 3, my lord.
Defendant number 3 in GA 32 of 2023 prays for leave to withdraw this application with liberty to file afresh as because they are on the ground of technical defects. My lord. Such prayer is allowed. The applicant of GA 32 of 2023 is permitted to withdraw the said application with liberty to file afresh. Now there is no applications.
Right now, I'll be filing an application within the next week, my lord.
So let us a date can be fixed. In the meantime, if you come with an
Yes,
application,
kindly
well and
fix
good.
the date after 3 weeks, my lord. I am going to file the application next week. Within the next 5-10 days, it will be heard out.
What heading? The suit will come.
for framing an issues matter and for witnesses.
I'll just indicate the difficulty. Defendant number 1 is now dead. That needs to be regularized before issues can be framed. The written statement filed by on behalf of defendant number 1 is also cannot be looked into, my lord, for framing of issues because she's dead.
One of the son of the defendant number 1. Defendant 1 is the sister is claiming that mother has given her share to the sister. I have no objection. Kindly heard the suit and decide.
Okay, just let it appear after 20. Let this matter appear on 31/7/2025. Just I'm giving it after 2 weeks.
Yes, my lord.
And for framing issues, matter, the issue has to be framed on that. Because now we have to proceed for
31/7/2025 under the heading to be mentioned.
I'm extremely grateful to my lord.
I
Should I appear for Milord the plaintiff? Milord, my learned friend Milord, being the defendant Milord, had filed an application under section order 7 rule 11.
So you have filed your opposition.
Yes, Milord, the opposition is come.
What is the matter about? Let's see.
Milord, my order 7 rule 11
record ta dekh.
on the point of only limitation.
Yes.
Your lordship will take my GA 11.
Yes.
Page 5, para number 8.
Para number 8.
Yes, my application GA 11.
Yes.
Instead, the said defendants have sought to file the present suit being such and such, which is ex facie barred by limitation. Now, why I say similar, will kindly take page 23 of their plaint. The plaint is annexed to this application. Your lordship has to see. I'm sorry, my lord. Kindly take page 24 first. I will show the prayers first. GA 11, page 24.
Yes.
That will kindly see prayer A.
Yes.
Decree of declaration that the plaintiffs are the owners of premises number such and such. Prayer B, the decree of eviction and khas possession of the suit property more fully described in Schedule A. Then, my lord, mean profit C and D. So, their prayers are decree of declaration that the plaintiffs are the owners. It is their suit. And my eviction from the suit property. Now, on what strength your lordship will take?
Yes, paragraph 18.
18.
Yes.
I'm grateful. Paragraph 18 is the only pleading that they have pleaded insofar as the cause of action is concerned. The cause of action in the instant suit arose on 24th February 1994 when the deed of lease expired by efflux of time, and since the said defendants are still in wrongful possession of the suit property, no part of the plaintiff's claim in the instant suit is barred by any law of limitation. This is the only cause of action. That means, your lordship, they are claiming that on and from 24th of February 1994, it was a 21-year lease deed. That expired on 24th February 1994. So, from that is the date when the cause of action of the plaintiffs against the defendants had arisen. Now, your lordship, I will show the various paragraphs of the plaint. Lordship will take first paragraph 2 at page 11.
Yes.
The predecessor in interest of the defendant number 1 and or the defendants and or its members are an incorporated persons were in unlawful possession of the suit premises since 25th, the very next day on which the lease had expired, till the date of institution of the suit. Then your lordship will turn over to page 13, paragraph 6. On or about 24th February 1994, the said 21 years period under the said lease, under the said deed of lease dated such and such expired by efflux of time when the said Mihir Kumar Law, acting the sole trustee of the trust estate under the name and style of the plaintiff number 1. The said Mihir Kumar Law did not renew the lease, and the said lease or execute the new lease in favor of defendant number 1 upon the expiry of the said stipulated periods of lease or even thereafter during his lifetime. Lordship will take thereafter paragraph 10, page 19. Paragraph 10, 4 or 5 lines, my lord, from the top. Thus the defendants. Your lordship has got that.
Yes, para
13, page 10. The 6th line your lordship will take.
Yes.
From the top. Thus the defendants are having no legal right to retain possession of the suit premises after the expiry of the period of lease. As aforesaid, since the defendant failed and neglected to make over possession of the suit premises to the plaintiffs, at the said defendants and each of the members
thereof are unauthorized and or illegal occupiers of the said suit premises and are liable to be evicted by an order and decree of this honorable court. Then the next paragraph, Your Lordship. Para 14. Since the said defendants are in wrongful possession of the suit premises with effect from 24th February 1994, the said defendants are liable to be pay damages and or mean profit such and such. So throughout the pleadings of the plaintiff and for the purpose of satisfying Your Lordship insofar as Order 7, Rule 11, I will only show the plaintiff, nothing beyond the plaintiff. I will only rely the plaintiff.
Yes.
So the entire pleadings as envisaged in the plaintiff by the plaintiffs as well as the various paragraphs therein and the main paragraph of cause of action says that their cause of action has arisen only on one day. That is immediately when the deed of lease had expired on 24th February 1994. After the 21 period lease term had expired by a flux of time. So the lease had stands determined on that date, thereby attracting section 106.
Yeah.
111, I'm sorry. One of the mode in 111 is a flux of time, expiry by a flux of time.
Anyway, here the point is on the law of limitation.
Yes. So when does it start? The question falls is when does the limitation period start to run for the plaintiff? And according to the plaintiff, it starts to run admittedly on 25th February 1994. And the suit has been filed.
2009, I think.
Yes, 2009. After 18 years. At best, my lord, yes, 15 years. I'm sorry. At best, my lord, they can come under Article 67 of the Law of Limitation, 1963, which prescribes a period of 12 years. Your Lordship will take the Law of Limitation Act, Article 67 once. Your Lordship, may I take Your Lordship's leave? I'm led by Mr. Gupta.
Plaintiff, Your Lordship has seen, my lord. The date of cause of action is 1994. Now, Your Lordship would kindly have a look at Article 67 of the first schedule to the schedule to the Limitation Act, my lord. Should I hand up a copy, my lord? May I hand up? And we'll kindly see Article 67. By a landlord to recover possession from a tenant. The period of limitation is 12 years. Then kindly marks the next expression when the tenancy is determined. My lord, I'll take your lordship to 111A, my lord, but kindly also sees section 27 of the Limitation Act.
Yes.
Kindly sees section 27, extinguishment of right to property. At the determination of the period hereby limited to any person for instituting a suit for possession of any property, his right to such property shall stand extinguished.
So, my lord, his right, if any, in respect of that property would stand extinguished on the expiry of the period for limitation so prescribed. Now, your lordship would kindly have a look at, my lord, the Transfer of Property Act. Your lordship has seen Article 67 language. May I only just place for my lord's satisfaction, my lord? Article 67, the language is when the tenancy is determined, that is when the limitation period commences to run.
This is a case of lease.
It's a case of lease. So lease tenancy, my lord, those are, my lord, really held, my lord, at par, my lord. Kindly, my lord, takes a look at section 111 of, my lord, the Transfer Property Act.
Yes.
And 111, the heading of the section is determination of lease. A lease of immovable property determines then A by efflux of time limited there. So it's a case of efflux of time and a determination of lease. This determination of lease is, my lord, the language of, my lord, Article 67. When the tenancy is determined. So, my lord, this coupled with, my lord, section 27 of the Limitation Act, my lord, extinguishes any right of the landlord to get back possession. And he loses the right in the property.
So regarding limitation, you have relied upon 67, Article 67.
Article 67 read with section 27 of the limitation.
27, and here it is 111.
Here is 111A.
The lease is determined.
Yes, 111A.
Yes.
When it is the lease is determined by efflux of time.
Right.
It's their own pleading, my learned junior had indicated. It's their own pleading that 1994, that lease of 21 years has expired by efflux of time. It has not been renewed. So, my lord, this is determined. My lord, now, my lord, the law on a Order 7 Rule 11D case, which is, my lord, part by law.
Just a minute.
Yes, my lord.
তিনটের সময় কি আর কোনো ফিক্স ম্যাটার আছে? উইটনেস অ্যাকশন কি আছে কিছু? তিনটের সময় কত নম্বর আইটেম? কত 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 আইটেম? ও আচ্ছা আচ্ছা। 100 সময় ছিল, কিন্তু ওটা কি হয়নি নাকি? না না, ওটাতে মেনশন করেছিল তো কোথায়? হ্যাঁ, আচ্ছা আচ্ছা। তাহলে তিনটেতে, তাহলে কোনো রকম তো ওইটা ওই আচ্ছা, তাহলে চারটে কত আছে? ওই 53। তাহলে এক কাজ করুন, ওই 53 আইটেম 53, হ্যাঁ 53 আর 105, ঠিক আছে, 53 আইটেম 105 আর 108, ঠিক আছে, বাদবাকিগুলো রিলিজ, ঠিক আছে। তাহলে 53 থাকছে। তিনটের সময় যেটা ছিল 50, এটা তো এটাও কি তিনটের সময় ছিল 50 আইটেম? হ্যাঁ, ও আচ্ছা, তো আলাদা। তাহলে 53 আজকে 4টের সময় 53 53 3:15 হলো 108, আর ওই তো 108 53 আর ওই 105 এই তিনটে ম্যাটার বাদে, হ্যাঁ, বাদ বাকিগুলো রিলিজ করে দিন। এটা হোক, মানে এক্সেপ্ট 108, 105 আর 53
কিছু বলবো
আদার্স রিলিজ। না না, একটু পরেই হয়তো ডাকতে হবে। হ্যাঁ, ওটা তো 4টের সময় ডাকতেই হবে। আপাতত এই তিনটে বাদে 53, 105 আর 108 তিনটে বাদে বাদ বাকি সব রিলিজ।
ওইটা দিয়ে শুরু করতে চাই।
Item number 3, 53, item number 105, and item number 108, except other matter released for the day.
I'm paying for 7 days time to file my reply.
Okay, just let it be over. Yes, you proceed with this matter.
Yes.
Except these 4 matters, others are released.
Lord, may I hand up this judgment? I'll send a copy. Copy আছে আর copy আছে? Copy দিতে হবে তো। আপাতত নেই। একটু পরে দেখ প্যারাগ্রাফ গুলো দেখ করে দিয়ে দাও স্যার। Kindly takes a look at this judge. This is the latest Supreme Court judgment which we could find on 711 D point, which is barred by law on the issue of limitation, where both the courts below had dismissed the application on the ground it's a mixed question of law and fact. Supreme Court said that it's clearly barred by limitation and has rejected the plaint. But kindly takes a look at paragraph 2, 2024 SCC online SC 3844. I mean, 3844. Kindly takes a look at paragraph 2. Your lordship would find that it's a case of order 711D. May I place it? This appeal is filed by the defendant number 1 against the order dated such and such passed by the High Court of Judicature, whereby the High Court dismissed the said application referred by the appellants challenging the order dated such and such. By the said order, the trial court rejected the application. Similarly, it was a judgment of affirmation where both the trial court and the High Court dismissed the order 7 Rule 11 application on the ground it being a mixed question of law and fact. From that, the Supreme Court has upset that and has rejected the plaint. Kindly takes a look at paragraph 4. This was an issue which concerned articles 58, 59 and 65 of the Limitation Act. Now, we'll kindly straight away come to paragraph 23, Your Lordship.
Para 23.
23, Mulad. This would be at page 34 of the judgment. Mulad. The pagination is at the top, Mulad. Further, in the aforesaid suit, has your lordship got it, Mulad? In the aforesaid suit, the respondent number 1 also sought possession of the suit properties based on title. As per Article 65 of the Limitation Act 1963, the possession of immovable property or any interest therein based on title can be sought within 12 years. From the records, it is evident that the possession of the subject properties was initially with the government of Maharashtra, then with the such and such, and thereafter with the defendant number 1, and it can be safely said that for at least a century, the respondent number 1 nor his predecessors have been in possession of the properties after the grant of Inam. The plaintiff has failed to sue the defendant or state for possession within 12 years. We have already held that the title claim of the plaintiff is barred by limitation, and therefore the claim of possession is also barred and consequentially the relief of recovery of possession is also hopelessly barred. Moreover, the plaintiff has not produced any document. I'm not troubling your lordship with that because those are factually different. Then 26 at page 36 of the report. And it starts with at this juncture. At this juncture, we wish to observe that we were not unmindful of the position in law that limitation is a mixed question of law and fact, mixed question of fact and law, and the question of rejecting the plaint on that score has to be decided after weighing the evidence on record. However, in cases like this, where it is glaring from the plain averments that the suit is hopelessly barred by limitation, the courts should not be hesitant in granting the relief and drive the parties back to trial court. We again place it on record that this is not a case where any forgery or fabrication is committed, which had recently come to the knowledge of the plaintiff. Rather, the plaintiff and his predecessors did not take any step to assert their title and rights in time. The alleged cause of action is also found to be creation of fiction. However, the learned trial court erroneously dismissed the application filed by the appellants under Order 7 Rule 11D of the CPC. The High Court also erred in affirming the same, keeping the question of limitation open to be considered by the trial court after considering the evidence along with other issues, without deciding the core issue on the basis of averment made in the respondent number 1 plain, as mandated by Order 7 Rule 11D of the CPC. The spirit and intention of Order 7 Rule 11D of CPC is only for the courts to nip at its bud when the litigation ex facie appears to be a clear abuse of the process. The courts, by being reluctant, only cause more harm to the defendants by forcing them to undergo the ordeal of leading evidence. Therefore, we hold that the plaint is liable to be rejected.
Yes, each case has to be decided on its own merits.
Yes,
Whereas from
yes,
the plaint,
absolutely.
it
I need to
appears
satisfy, yes.
it has to be dismissed.
Yes. So I need to satisfy it is ex facie barred by limitation. Otherwise, my lord, your lordship would not pass an order in 711 and frame that as one of the issues in
preliminary issue, or
as a
whatever it is.
Yes. But if I can satisfy its ex facie barred, then your lordship
Plaint itself.
from the plaint itself. So your lordship has seen from the plaint that my lord, their case is that it expired by efflux of time in 1994. And they have filed the suit after 15 years. The period of limitation is 12 years. Now, my lord will kindly Bolo. Now, your lordship would kindly permit me to place 2015 and may I place 2015 volume 4 Calcutta High Court notes, page 75. Now, this was a case of Article 67 and efflux of time. It's a division bench judgment of this honorable court. May I please? This appeal is directed against the judgment and decree passed by the learned judge, 11th bench civil court, on such and such, in title suit number such and such, by which the learned judge dismissed the suit. The appellant plaintiff instituted the said suit against the defendant's respondents, praying for eviction, recovery of possession of the suit premises, permanent injunction, and mean profits. Then kindly see paragraph 2. One such and such predecessor in interest of the plaintiff inducted one Devdash Nath, predecessor in interest of the defendants as tenants in one of the rooms in basement floor of block B of premises number such and such at a monthly rent of rupees such and such for running a printing press by executing one deed of lease on 6th July 1954. The deed of lease was made effective for a period of 16 years from 1st August 1954 to 31st July 1970. Rajarangal Didwania died on 9th August 1965, leaving behind his only son, such and such. Then Malad kindly skips 5 or 6 lines. Malad, the next sentence, the defendant did not make payment. Has your lordship got it, Malad? The defendant did not make payment by virtue, of rent in respect of the suit premises to the plaintiff or the receiver appointed by the High Court in the partition suit after expiry of the term of lease deed on 31st July 1970. It is alleged that the defendant was in wrongful possession of the suit premises with effect from 1st August 1970 without making payment of rent of the suit premises. On 12th March 1998, the plaintiff came to learn that the defendant collected building materials for construction. Those are not very relevant. Then kindly see paragraph 3. This second sentence really. The specific contention of the defendants is that they are in uninterrupted possession of the suit premises after expiry of the term of lease on 31st July 1970 till the date of institution of the suit on 16th March 1998. The specific plea taken by the defendants is that the suit is barred by the provisions of Limitation Act 1963 as the plaintiff has not taken any step for recovery of possession of the suit premises or renewal of the term of lease or collection of rent from the defendants within a period of 12 years from the date of expiry of the term of lease on 31st July 1970. The defendants have specifically pleaded before the trial court that they are in possession of the suit premises by asserting ownership with the knowledge of the plaintiff continuously from such and such till the date of institution of the suit on 16 March 1998, that is more than 12 years, and thereby they have acquired title in the suit premises by way of adverse possession. The trial court dismissed the suit of the plaintiff by holding that the suit is barred by limitation under Article 67 of the Limitation Act. It is also held by the learned judge of the trial court that the defendants have acquired ownership in the suit premises through adverse possession of the defendants has not been established from evidence on record. The decision of the trial court is under challenge. And Mr. Such and such learned senior counsel appearing on behalf of the appellant submits that after the termination of the lease by efflux of time with the effect from 1st August 1970, the status of the defendants in the suit premises will be of gratuitous licensee and not tenant, and as such the provision of Article 67 of the Limitation Act 1964 cannot be invoked to negate the claim of the plaintiff. That is the contention of the plaintiff having suffered the decree of the suit being dismissed. This was the arguments. Then kindly see paragraph 6. Mr. Such and such learned senior counsel appearing on behalf of the defendants submits that the lease between the plaintiff and the original defendant is determined by efflux of time under Section 111A of the Transfer of Property Act 1882 after expiry of the term of lease on such and such. It is also submitted that there is no evidence of renewal of the lease or offer and acceptance of rent between the parties after 31st July 1970, and as such the plaintiff has right to recover possession of the suit premises within a period of 12 years from the date of determination of the lease as laid down in Article 67 of the Limitation Act. Mr. Such and such also submits that the title of the plaintiff in the suit premises will be extinguished if the plaintiff does not institute a suit for recovery of possession of the suit premises from the defendant within a period of 12 years after determination of the lease, that is 1st August 1982, by virtue of Section 27 of the Limitation Act 1963. The inaction of the plaintiff is for more than 27 years by not instituting the suit for recovery of possession of the suit premises resulted in extinguishment of the title of the plaintiff in the suit premises. Mr. Mitter contends that the possession of the defendant in the suit premises after expiry of the period of lease is continued as wrongful occupation by the plaintiff himself in his pleading, and as such the claim of adverse possession of the defendant in the suit premises is tenable in the eyes of law. Then kindly see the next paragraph. First sentence really not important, that is the factual aspect of that. Then the next sentence. The further admitted position is that the terms of the lease expired on 1st August 1970 and the lease was determined by efflux of time with effect from 1st August 1970 as per provisions of Section 111A of the Transfer of Property Act. It is not the case of either of the parties to the suit that the lease was renewed after 31st July 1970 or there was offer and acceptance of rent between the parties. What transpires from the evidence on record is that the original defendants did not make payment of rent either to the plaintiff or to the receiver who was appointed in connection with the partition suit after such and such. The possession of the defendant in the suit premises is described as wrongful occupation by the plaintiff in paragraph 4 of the plaint. Then Millard kindly skips 2 or 3 lines, Millard. Thereafter the sentence, in the above circumstances, we have to decide whether the provision of Article 67 of the Limitation Act 1963 was rightly invoked by the trial court to deny the claim of the plaintiff to recover the possession of the suit premises from the defendants. In Prakashpati Chopra, reported in such and such, cited on behalf of the appellant, the plaintiff lesser instituted the suit for recovery of possession of the tenanted premises within a period of 8 years from the date of determination of the lease by efflux of time, and the Honorable Single Judge passed the order for recovery of the possession of the tenanted premises. By upholding the said order, the trial court it is held by the Honorable Division Bench in paragraph 29 that where the lease expired by efflux of time, but the lessee is continuing in possession, he or she would not come within the purview of the definition of tenant under section 2G of the Act of 1997. This decision does not take into consideration whether the provision of Article 67 of the Limitation Act can be invoked. No, so this is really not applicable. Then kindly comes to the next paragraph, paragraph 10. In the instant case, the original defendant was inducted as tenant in the suit premises for non-residential purpose for a fixed tenure of 16 years, which expired on 31st July 1970. Whatever may be the status of the defendant in the suit premises after determination of the lease by efflux of time, the plaintiff, being the landlord, has the right to recover the suit premises from the defendant within a period of 12 years from the date of determination of the lease. The plaintiff instituted the suit on 16 March 1998, that is long after 12 years from the date of determination of the lease. Accordingly, we do not have any hesitation to hold that the suit instituted by the plaintiff for recovery of possession of the suit premises from the defendant is barred by Article 67 of the Limitation Act. We do not find any substance in the submission made on behalf of the appellant that the provision of Article 67 will not be applicable to the instant suit, since the plaintiff did not take any action against the defendant for recovery of possession of the tenanted premises within 12 years after the period of expiry of lease on 1st August 1970. The right of the plaintiff in the suit premises is extinguished by operation of law as laid down in section 27 of the Limitation Act. Similarly, your lordship would see the last two lines in paragraph 12, the appeal is dismissed. So 711 allowed, appeal preferred by the plaintiff, the order is sustained. Kindly, my lord, now this was possibly handed over to your lordship by us on the last occasion, 2020 volume 9 Supreme Court cases. 2020 volume 9 Supreme Court cases 393.
See if it is there.
May I hand over? May I hand over? 16. Kindly takes a look at paragraph 16 of this report.
No, the judgment of this court of the coordinate bench is with regard to this lease when the rights of the lessee after the expiry of the lease.
The one I was placing before this?
Yes, just with regard to Supreme Court judgment, the scope of Order 7, Rule 11.
The scope of Order 7, Rule 11,
In
that was
general.
also considering the Limitation Act. Order 7, Rule 11 in respect
Order 7,
limitation.
Rule 11 limitation.
Limitation.
But here limitation.
It is specific to Article 60.
Yes. No, this is with regard to the
But this is a
expiry of
division
the
bench.
lease.
It's a division bench judgment, your lordship, of this. The 2015 Calcutta.
Yes.
Now, my lord, this 2020 volume 9 Supreme Court cases 393. Now, kindly takes a look at paragraph 16 of this judgment.
Paragraph 16.
Yes, paragraph 16. Now, that your lordship would find, my lord, at page 410 of the report. Well, it starts with, it was also argued. Has the lordship got it, my lord?
Yes, paragraph 16.
It was also argued that the suit was within the period of limitation, as neither Article 67 nor Article 66 would be applicable, but the plaintiffs had a right to seek possession under Article 65 of the Limitation Act, which confers a right on the plaintiffs to seek possession from a person who is in possession by virtue of his title. It is for the defendant to prove that his possession is open, continuous, and uninterrupted, so as to ripen the adverse possession into the ownership. It was argued that the defendant had not denied the tenancy prior to filing of the present suit for possession. Since the defendant continued to be in possession of the after the expiry of the lease without any payment of rent, the possession of the defendant was not that of a tenant holding over, but that of a tenant at sufferance. But this was argued. Then, my lord, paragraph 18. We have heard the learned counsel for the parties. The question that would require to be examined is as to which article of the Limitation Act would be applicable in the present case. That is Article 65 as asserted by the appellants, or Article 67 or 66 or 67 as ascertained by the respondent. But here the articles are quoted. Then, my lord, kindly sees paragraph 19. Section 111 of the Transfer of Property Act provides that that 111
Yes, that is discussed.
which was discussed. I'm not troubling your lordship with that. Then kindly comes to paragraph 29. The defendant was inducted as a lessee for a period of 20 years. The lease expired on 23rd September 1974. So, that was the fact, that it was expired on 23rd September 1964. Then, kindly takes a look at paragraph 33. But here, Article 67 of the Limitation Act was considered in a judgment which was relied upon in this judgment. Then, then I need not trouble your lordship with the other portions. The various judgments are quoted. Then the finding at paragraph 39 onwards. And here the court found that this suit was filed within 12 years of the tenancy by efflux of time. That is why, the plaint was not rejected. But, I was showing this judgment only for the purpose of the ratio that, where
yes, under
the other articles would not
67.
apply. 67 would apply. That is why, I was showing this judgment that why 67 would be attracted. Paragraph 39, the last line kindly sees. The plaintiffs have filed the suit for possession against the defendant on the basis of determination of tenancy. Such suit is governed by Article 67 alone. That is why, I was placing this judgment. I'm grateful to my learned junior, I missed this. But that is why I was placing this. And also Article paragraph 40, the first line. In view of the above, the suit for possession would not be covered by Article 65, since there is a specific article, that is Article 67, dealing with the right of the lessor to claim possession after determination of tenancy. The appellant plaintiffs have claimed possession from the defendant, alleging him to be tenant, and that he had not handed over the leased property after the determination of the lease. Your lordship would see it's tenancy and lease are used, in synonymously. Therefore, such suit would fall within Article 67 of the Limitation Act. But because in this case, the suit was
Anyway, as
within
per this judgment, it comes under Article 67. If
That is
it
the
comes
only
under
purpose.
Article 67, 12 years is the period.
12 years is the period. That is the only purpose for which I am placing this article, this judgment. I'm sorry, Mullah. The defendants had argued one more point where I need to show some authorities. Could I come back on any other day?
Yes.
But they had taken a point, my learned senior friend, that it's a continuing cause of action. So I shall show judgments to indicate that what is a continuing cause of action and how this cannot be one. So I need to show some authorities to try and
So in the opposition,
In the opposition and also in course of arguments when it was taken up before the exchange of affidavits.
conclude on the next day.
Yes.
Yes, recorded noted. Learned advocate for the petitioner defendant submits but could not conclude the arguments. The matter stands adjourned till July 2025. Yes, I'm keeping it on 30th July.
But any day barring 30th, second, first or 31st, any day, but any other day.
31st July 2025.
31st.
Yes. Okay, 31st July.
Great.
3:15 PM. 3:15. আছে 3:15 আছে
31st অসুবিধা ফার্স্টটা দেখবেন
লাস্ট ম্যাটারটা কি 3:15 তো
ফার্স্টে হবে 31st না হয় ফার্স্টে হবে
এখানে যে লাস্ট ম্যাটারটা আছে এটা তো দেওয়া আছে 3:15 ফর ফাইনাল অর্ডার আজকেই রয়েছে 31st কোনো ফিক্স নেই 31st ওটাকে ইয়ে করে দিন 2 PM করে দিন I'm keeping it at 3 PM on 31st.
ফার্স্টে হবে কি
Or I can do one thing. 2nd August is a working Saturday. You can come on 2nd August. Comfortably, you can come.
I do not have any objection. My learned senior friend may not come.
Because that would be the best opportunity.
No. Let him argue. I'll argue on the next. Let him come and argue. I'll argue on the next.
Okay, so 31st there is difficulty. 31st.
Yes, my lord.
আচ্ছা ছেড়ে দিন ওটাকে 4th August করে দিন
4th আমি করি আচ্ছা ঠিক আছে 4th August
4th August ইয়ে করে দিন 3 PM করে দিন 2 PM. Yes, 2 PM.
2 PM. Great.
Depending on the council. জানি oblige.
Fixed matter take দিন 108 আচ্ছা 2 PM টা আগে ডেকে দিন 2 PM ওই
Item number 105.
105, I am for the petitioner. It's an application for grant of probate.
Yes.
But I have taken out the report from the department.
Yes.
Which suggests that, Lord, it suggests that, Lord, after the citation, there is no caveat has been lodged. Told me that if there is no caveat, it should be treated as a non-contentious cause.
After all, you have to examine the attesting witnesses to prove the testator's signature.
But I followed that in the other matter, but not only one thing in our High Court, Milord, the rules that we follow.
Whatever it is, you see, to prove a will, that is necessary. So
I'm not, on that aspect, Milord, I'm carrying, Milord, the coordinate bench, Milord, in all along for all.
whatever it is, I can fix it for.
But the non-contentious cause, Milord,
No, that's
by
it. As per the statutory provision, that requirement is there. Okay.
For our High Court, the rules are different.
Maybe, but you see.
Lordship kindly peruse,
So-
I am carrying one judgment. If
No, no,
Lordship
that
thereafter,
discretion, that discretion is there, okay.
if Lordship follow.
Okay, then come with the decision on the
Yes,
next
I'm
day.
carrying it, Milord. I'm carrying it. If Lordship
Come
permits
with
me,
the-
Milord, I can Milord, satisfy Lordship on that aspect, Milord. In non-contentious cause, Milord, our High Court from last 200 years, the practice is that the will is proved by the affidavit of the attesting witness, Milord, which is filed here. So that I am carrying judgment which laid down the procedure. I will observe that for last many years from the beginning of our High Court,
Yes, record an order. Learned advocate for the petitioner is present. As no affidavit.
No caveat has been.
No caveat has been filed in this application. That this matter be treated as non-contentious. Learned advocate is granted liberty to come with relevant authorities on this issue. On
Lordship will give you 15 minutes time on any day. I'll satisfy. I'm carrying the authorities right now, but
6/8/2025 at 4 p.m.
6th August. Item number 106, Milord. It's connected matter.
106.
Yes. 104, Milord. Sorry, 104. Same person's second will regarding different property.
No, but here this
The same certificate is there as well in that matter.
No, here this clarification is only with regard to 115.
That clarification is, this is prior in that matter as well. This
If
was
it is-
lately done, so that
If it is there, then it will be taken up. Anyway, for the time being, let this matter appear. Okay.
the other one should be tagged together. Otherwise, it will remain in the list.
Acha, 104.
Same day it
Let
can
this matter appear along with ELA 115 of 2010.
6th August at 4 p.m.
On
Grateful.
6th August 2025 at 4 p.m.
Grateful. May I take back this original certificate?
Number 108.
Did it?
Yes. Yes, the matter, I have gone through the matter. It was ready for orders on the earlier date, but anyway, this bench did not sit, so orders could not be passed.
My lord, in this matter, I intervened by filing an application, my lord. And on 4 applications.
Whatever is there, I am not concerned with this GA 42. If there are other applications,
My lord, I have filed appeal against the order. My lord.
No.
All
Not
the-
against 42.
Yes.
I am
42,
concerned
your
with
lordship
GA
can-
42.
Yes, I have filed appeal. My lord, the order was passed on 3rd of April, my lord, 2025.
Is
I
there
will
any
just-
stay of further proceedings on
No,
this
no
application?
stay, but appeal has been, my lord, appeal,
GA number 45.
appeal. No. This is
No,
not
but-
correct. My lord, your lordship kindly order was passed on which, my lord, applications, your lordship kindly come to. My lord, order dated, my lord, 20.
There is no stay.
3rd of. My other friend is, my lord. Product है, यहाँ सुना क्या? That's it, yeah. My lord, 3rd of April,
From GA
my lord,
number 45.
my lord, 3rd of April, my lord, 2025. Your lordship kindly see the order.
I am concerned with any order with regard to this GA 42. Any
Yes.
GA
This is-
42, there is
my
no
lord,
appeal.
GA.
where is the appeal? Order against appeal.
Yes, your lordship.
Where
kindly-
is the order?
Your
Let
lordship
me
kindly-
see. Any order passed in GA 42?
My lord, your lordship kindly see the order.
My lord, I have handed over the copy of the appeal before your lordship. It's GA 45.
My lord, GA 45 appeal has been, my lord, your lordship kindly see the order passed by my lord Justice Patanayak on 3rd of April. Division bench, my lord, all the orders, all the applications are taken up together.
No,
All the applications.
this is the usual practice. Every time.
No,
someone-
this is not the usual practice.
My lord,
My lord, kindly see the order, my lord. My alternate friend is, my lord, saying, order passed by my lord Justice Patanayak. What is the kutha?
For 3 months. There is no appeal court order. It has not even been heard.
Arising out of CS 308 of 1872. Very well. Maybe there. But so far GA 42 is concerned. Yes. Justice Pattanayak's order is appeal from.
Yes, your lordship kindly see the order.
respect of GA 45, there is no.
Your lordship kindly see the order.
So,
Your lordship kindly see the order.
Which has been passed.
এক মিনিট বলতে আমাকে বলতে। Your lordship kindly see the
I
order.
have handed over just now to your lordship.
My lord, kindly see the order.
It is only GA 45. This is, let everybody finish, I'll make my submission after. So, my lord, what happened in this matter? Madam, may I?
Your lordship,
ask you one thing?
okay,
What of the matter? I am contesting the GA number 42. Now the 42, 43, 44, 45, all applications taken together and a common order has been passed on 3rd April. No. Let me finish, then you have the.
If a common order is passed, this court is not concerned with common order. This court is confining itself to GA 42.
My lord,
42 order has been
the
passed.
common order, my lord, your
No,
lordship,
in Justice
Your lordship,
Pottonak's order, I did not see GA 42 probably.
your lordship kindly. My lord,
GA
your lordship,
42 separately is there.
no, this is not correct. My lord, this is, he is misleading my.
I don't do this word. I don't like this word. And my 30 years I've never misled a court. And I don't want to do it at this stage.
Your lordship,
And
kindly
these
see
are
that.
not sharp practices.
My lord, let me place my.
objection to this.
No,
My lord,
please.
My lord, let me place the
But
order.
I do not understand this word.
My lord, your lordship kindly place me the order. Passed by my lord Justice Pattonak. My lord,
I don't like this word misleading.
At the top.
They do this.
Use some better language.
My lord, your lordship kindly see the order. My lord, let me place. My lord, from the top. My lord, GA 42 was taken up. My lord, GA 43 was taken up. GA 44 was taken up. My lord, GA 45 was taken up. GA 45 is my application. And all the
One of 2000.
My lord, your lordship kindly see the paragraph 5. Mr. Amitesh Banerjee, learned senior advocate appearing in application number
Just a
GA
minute,
42
just a
to
minute.
24.
Just a minute.
My lord, what is this?
Which page?
Page of the order passed by Master Justice Pattonak, page 4. Order
Just a minute. No, this is not Justice Pattonak's order.
Your lordship kindly see the order
The
passed by
division
Justice
bench
Pattonak.
order.
Well, your lordship kindly see the order passed by Justice Pattonak. बराबर नहीं ऐसे बोलते हैं आना ना करें.
Long and short of it, there is no stay.
Kindly see. Well, first page of the order kindly see. Then submission of my learned friend.
This is Justice Pattonak's order.
Yes.
Yes.
This order has been challenged. All the applications were taken up together and submission of the my learned friend and application was taken up. That was considered, recorded.
The administration of the suit.
My learned friend, my lord, I am sorry, my lord, that I have used that language. But my learned friend, my lord, being a senior advocate, my lord, he should, my lord, place this order. Because my lord, again,
He get an opportunity to submit.
This is there. Okay, Justice Pattonak.
May I, my lord, now make submission?
That is there.
And may I have no interruption when I'm submitting?
Yes.
Have your lordship got the order?
Yes, Justice
May I
Pattonak's
present?
order I have.
Yes. Now, my lord, your lordship will come. Kindly come.
Last.
Your lordship will kindly come to straight away. Page 2 of the order. Your lordship doesn't have the order.
Yes.
Justice Pattonak's order, first is in GA 42, the applicant has made the following prayer. 43, following prayer. 44, following prayer. 45, following prayer.
Yes.
Abar interruption, my lord, may I have.
Anyway, let him submit, please.
Then comes my submission in 42.
Yes.
Lordship will find.
Yes.
Thereafter, my lord, your lordship will kindly come.
Page 3.
Thereafter, each of the applications are considered.
Yes, and last, the operative portion is so far GA 43 of 2024, prayer C of so and so are dismissed. And GA 43, 44 and or disposed of. Now, regarding elections, there is an order, specific order is there.
Yes, paragraph 13.
Now, your lordship see. Thereafter, in reply or to Mr. Banerjee, page 11, page 12.
Page 12.
Page 12, that is my reply.
Yes.
Then page 12,
Yes.
12, paragraph 10.
Paragraph 10.
That comes up with as far as GA 43, GA 44, GA 45, Then submissions on that. Now prayer B in GA 43, paragraph 11.
GA 43, paragraph 11.
Look, page 13.
Page 13 of this order which you have placed.
Yes, yes.
Yes.
Well, it deals with GA 43, 44.
Yes. And 45.
Yes, 45. Thereafter, after rejecting all the prayers.
Now the question is, this order was passed when? This is
April 2025.
no. When? Date of this order?
Yes,
3rd of April.
3rd of
April 2025. Okay. Thereafter, the appeal was preferred.
And
in the meantime, the elections were held.
Yes, and
Yes.
Elections were held and then.
In the meantime, the elections were held.
Nobody contested the election. That is the main thing.
No, very well. I'm
No,
just concerned with
and
this thing.
I'll tell your lordship. Now your lordship will kindly see application কাগজটা কোথায় যেটা তুই তুলে দিলি,
দিলাম।
which I just handed over.
এটা নাও আরেকটা কপি।
No, appeal you have preferred on which date? Because this is the 3rd April.
As far as GA number 45,
My lord,
not
against that,
42.
my lord, against that order, appeal has not been
GA,
preferred against the
as
application.
per the order of Justice
Appeal
Portona
has been
Act,
preferred against a
all
particular order.
these matters were taken up for consideration together.
But the appeals, my lord, today,
The entire order is challenged.
well, your lordship gives me leave to. I can't appear with a monkey circus going on over
Please,
here.
please,
Well,
please
this
say
is the
this,
word,
this is
my
not
lord, like my
expected.
learned opinion,
Please.
Mal is using monk
Yes.
circus.
Yes,
Well, he's a senior advocate.
yes, going on.
I am not saying.
Before your lordship. Yeah.
Well, he's a senior
Question
advocate.
is, now the question is,
Then we can use that.
what last occasion I was perusing the order of Justice Portona Act anyway. Whatever his lordship dealt is this is his lordship considered all, okay, and have come with this observation, okay, regarding elections.
But thereafter, my lord, the appeal has been preferred.
Now what happened is GA 42 of appear in the list before the judge taking up interlocutory matters on
Here.
9 June 2025
Yes.
for
That's
approval of the
how-
steps. For approval of the steps
Yes.
and confirmation of the election results.
Yes.
Now after this order was passed, election was held.
Yes.
Election was
Completed.
held. It was
held,
declared.
done because nobody contested the elections. It was results were declared uncontested.
No, very well. I am not
Held,
interested who is held.
held.
But after this order was passed, directing the elections to be held, the matter be listed on 9 June 2025 and the matter being placed before the appeal court. During pendency of the appeal, election was held.
No, appeal was not preferred then. Appeal was preferred thereafter.
When?
Appeal was filed, my lord,
ওই তো
report there.
এটা পরেরটা
No, appeal was preferred on which date? No, this is the appeal court's order.
Appeal court's order, appeal
No, no.
came up much later.
মাছ লেটার আমি দেখে বলছি দাও
Court's order is 12th June.
12 June. Order was
Well,
passed.
yes, June 12,
Ah,
and their lordships.
time everything was concluded.
And when was the election results declared? That is, the date is of probably June
in April
6th. No, June 2025. The election.
He paper on 14th of April 2025.
Anyway, but the appeal was not passed. No order
Second of
was. The appeal was not moved.
Yes.
Well, this
Appeal was
2nd of June the report was
Very well. During pendant, that means I have to consider that during pendency of the appeal, the election was held.
election was.
Yes.
Ele-
That means there was no interim order from the appeal court.
No,
My lord, your lordship kindly, my learned friend finish, then I shall.
I am just concerned with this few clarifications.
Yes,
That during pendency of the appeal, the election was held
yes
and results were declared.
yes.
Yes.
Who has contested or not, I am not interested.
No, absolutely. But the
So-
report has been filed before your lordship.
So till today, is there any stay of Justice Portona Act's
No.
order?
Not only that, there is no, my lord, today before your lordship, there is no exception to this report.
Okay. No, I am not considering that exception. Okay.
No, so therefore.
At any
so
point of
that's
time,
all
they can
your
come.
lordship will have to do is,
Any point of time, they can come and challenge whatever they want.
but they can most welcome to tell. I am not that. But today, all I am saying is today, what is before your lordship, it is the report. Lordship will confirm the report.
That is why I am seeking this clarification that after Justice Portona Act's order, appeal was preferred.
No
But,
stay.
but very well, there was no stay. During the pendency of the appeal, election was held and the report was submitted. And till today, there is no order of stay of Justice Patronak's order or stay of any further proceeding. So this is the only thing I want.
No.
Yes, yes, you please tell whatever you want.
My last pen will submit, then I will make.
No, I have said it now.
You submit. You please submit, yes.
May I submit? So, my lord, initially a suit had been filed in 1872. So, one after this is an abated suit according to us. That point was taken by my Lord Justice Devanshu Gosaks. No order can be passed in connection with CS number 308/82. Suppressing that fact, they have obtained an order. Now, some of the my Lord, the devotee filed a appeal application. 2 appeal has been filed before the division bench. Now they have taken the plea, my friends, client, my lords, on 7th of April, November 2022, that a similar facts and circumstances suit is pending before the civil court, that is the single judge. So no appeal cannot be entertained. Now the division bench said, we want to see the fact of the plain or the suit, place the plain. Plain has been placed before the Honorable the division bench. Considering the plain, the prayer of the plain, prayer of the GA, and prayer of the this the appeal, the Honorable division bench passed an order to file affidavit in opposition. Because of that, the plea, in the plea, prayer was this, this the management which has been running from the 1929 and misappropriation of the huge fund of the Dakshineshwar temple. The bill is the proper this the adjudicating court, considering the Surabhi Bose judgment of the Kalighat case. Now suppressing that said bill where they have used the affidavit in opposition, file GA 42. We contest the GA, I being a one of the Sevite contest the GA. No, this GA cannot be entertained since they contesting.
So that means GA Justice Patronak's order was passed on contest. You made your submissions.
No, it
was passed on contest.
I will complete the submission. In that GA, I contest by way of filing the affidavit in opposition. That no order can be passed by this honorable court. Because of that, same issue is pending before the appeal bench.
What is the observation of Justice Patronak on with regard to your non-maintainability? Any observation made by his lordship?
Yes.
Well, which paragraph, please?
So now this is not the Mala that
No, which paragraph that this is not maintainable? Whether it was accepted by his lordship?
Yes,
No,
yes. Your lordship, kindly, may I place?
No, which paragraph, please point out.
I am placing Mala. Chance because of that, this is not the. If your lordship kindly.
Come to paragraph 10.
Paragraph?
Paragraph 10.
Yes.
Internal page 12.
Yes. So it is observed that accepting the election of the Board of Trustees,
yes,
the other matters are pending before the Honorable Division Bench.
No, my lord, I clarify.
Yes.
Now, election for purpose of taking over the management. My prayer in the appeal that for constitution, a constitutional committee for taking over the management. So that means election only purpose of taking the management of the Dakshineshwar. A constitution of a constitutional committee as per the law. So that is the same issue. That issue without considering. Now, at interim measure.
Is there any restraint order by the Division Bench holding public interest litigation restraining the parties not to move any further.
I will come. I will come.
Will come.
My lord,
Okay.
then, my lord, no interim order has been passed. And it will pay you. When the matter is under session before the division bench, that issue has been considered by the my lord Justice Mamta. Yes, if any order is passed in appeal arising out of the order of the Honorable Justice Portonayu, and any order passed by the another division bench in appeal matter, a contradiction order may become. That's why this pair was made for confirmation of the election.
No, what is this?
My lord, kindly see the order of the my lord Justice, my lord this Manta. So that's why all together, all the matter to be heard analogous, matter assigned before the Honorable Justice Soposachi Hostage and my lord Justice Uday Kumar. Last day matter was appearing item number 5. So they have not seeking the confirmation before the division bench. Now they have come before your lordships. Apart from this, they should come in the fair before your lordships. Because of the GA 42 has to be mentioned that a similar issue is pending before the division bench. That this is my objection, that opposition is still pending before your lordship. But before considering confirmation, my opposition has to be dealt with. Again, my lord.
Yes, it will be dealt with. I'll consider your objection.
Consider the division bench order.
Yes.
The very clear, my lord, is if any order is passed by my lord Justice Manta and order of the my lord the appeal court, this is a contradiction order may be passed. That's why, my lord, the matter, all the matter, my lord, they assigned before the Honorable Justice Soposachi Hostage. Yesterday matter was my lord one listed, but unfortunately that item number 5 not taken up by their lordship. So now at this juncture, my lord, your lordships can entertain at this juncture unless matter can be referred before the division bench.
This is June 12. Yes, Mr. Banerjee, elections declared on?
June,
No, there's elections held after April.
Yes.
And the
And
elections
there's
were declared also.
Yes.
Yes, election process has been completed and handing over management charge.
Yes.
Only that is pending. This is observation.
Yes, that is, if your lordship looks at the report of Justice Chotima.
Yes, that is there.
Yes, that is dated 2nd of June.
2nd of June.
Yes, and my lord, the election.
And this is the June 12 order of the division bench.
Yes.
Okay, June 12, June 2 is the order of that is the report of Justice Jyotima Bhattacharya.
Yes, Lord, if your lordship comes to page 19 of that report. Lordship takes the second last sorry.
Anyway, please. এই রিপোর্টের ইয়েটা দেখি ইয়ের মধ্যে আছে
সিল খামে আছে
Not at this stage.
Page 19, if my lord kindly comes to.
Page
19 of the report. If you look at second last paragraph, is notice related to the election results was uploaded on the official website of the temple on 6th of May 2025 and was published in the abridged form in the newspaper.
Yes, that is there.
The election was completed by then.
Handing over charge has not taken
No,
place.
handing over now that your lordship will direct. Your
This
lordship
is, yes,
actually-
this is 2nd day of June 2025. The division bench order, that is no order, it's a matter released with some observation. That is 12th June 2025.
But even then,
My lord,
the
the
division
application-
bench did not stay.
My lord,
Yes.
Any order. The
My lord,
division-
your lord,
No, but you see, the order was passed in
my lord, your
April, but
lordship,
you have moved the division bench
They
when?
asked for a stay, the stay was issued, but
your
not
lordship,
recorded.
yes, my lord, your lordship kindly consider the order, my lord, which is required to be stayed by the division bench. Your lordship kindly come to paragraph.
No, is
My
there
lord, your
any
lordship-
stay of this order?
My
Please
lord,
just,
your lordship kindly consider, which is the subject matter before the.
I am not concerned with subject matter, I am concerned with GA 42. Okay.
Yes, yes.
If GA 42, Justice Pattonaik has directed holding of election, publication of the report, that has been
Yes.
complied with.
Yes.
You have preferred an appeal. Is there any stay?
No.
So there is no stay. Appeal has been, my lord, section 5 application and other application has been allowed. My lord, that application could not be heard on that day because my lord Justice Mantha was of the view that if any order is passed, my lord,
So
staying,
June 12, the matter was released. So did
matter
you
is
get it?
appearing in the list, my lord, appearing in the list. In the, my lord, before my lord Justice presided over my
But till today, there is no stay of the order of
my lord,
Justice
if
Pattonaik.
the order, my lord, application is appearing, my lord, the could not be heard. My lord, your lordship kindly, my lord, do not, my lord, pass any order confirming the, my lord, election. Your lordship kindly let the appeal be heard. Then your lordship kindly pass that till that date. Your lordship adjourn this matter till that day. Your lordship, this matter could be heard at any day.
Delayed. I'll tell you
No,
lordship one
this
thing.
is not the proceeding.
I'll tell
My
you
lord,
lordship one thing.
my lord,
When
since
you
then,
say-
my lord,
my
order
lord-
Anything, this order will always be subject to the final order passed by the appeal court. That clarification, whatever is that clarification will be there.
Yes.
My lord,
My lord,
your-
may I say this one more thing? If my lord takes the appeal.
Because whatever, whoever takes charge or whatever be so,
Yes.
it will be subject to the result.
Result of
They have to, it will be binding upon them.
Yes, obviously, my lord, if the high, my lord, end of the day, my lord, may I say this? One of the reasons why Dakshineshwar temple carries on so well without any problem is that it is under the scheme of administration of the High Court. And today, every 3 years, no election can be held without leave of the High Court. High Court appoints an administrator. But and no person than a former Chief Justice was appointed to conduct the entire thing.
The original scheme was framed by whom? Justice Banerjee.
No, the original is long ago. Thereafter, in 1986, the last frame
86,
scheme is 1986. That was Mr. Justice Banerjee, and the person who did the whole thing was Dr. Taposh Banerjee,
Scheme was-
father of what was the one. He did the entire scheme. Since then, every 3 years, every 3 years, the trustees come to the court. Every 3 years, the prayer is made. Election is thereafter held in accordance with that scheme, in accordance to the up-to-date voters. This time also, the administrator, if you have to see the report, has considered all the persons whose preceding generation has died, the new persons that will be made, new fresh voters list is published, everything in according to their proportional of their shares. Everything has been done. I have to say this, Justice Jyotima Bhattaji, although he doesn't take remuneration, he has done a painstaking job. He sits and does. And your lordship looks at the report, I'm sure your lordship has seen. Your lordship find that the meticulous job that he does entirely by himself. No assistance from anybody. He does everything himself. And after that, today all I'm saying is, let this controversy, if today in the appeal, it is my learned friends are such, as of this date, there's no stay. And my Lord Justice Jyotirmoy Bhattacharya take over the charge till the disposal of the appeal. We have no objection. But because of nobody is, we have the separate. I have no interest for getting the.
Yes. Record an order.
My Lord, let them. My Lord Justice continue. We have
Yes.
no problem.
Yes, what do you,
Paragraph 7 onwards.
paragraph 7?
Paragraph 7 onwards of the division judgment.
Yes, I've seen.
What is the language of the order? The election process has been completed.
Yes.
And the management is charged to him to charge the so division bench.
Has been kept pending orders from the single bench, not from the division bench.
Yes, yes. So my lord,
Very well, very well. I have
Three paragraphs. Order could not be passed because.
anyway at the end of the day, there is no stay of the order of justice for tonight.
Then, my lord, you record my submission.
Yes.
Yes, my lord. Kindly record. Kindly consider my opposition.
What is your opposition?
Opposition in GA 42.
GA 42? Yes.
Yes.
You have submitted. Yes, that is there in the order.
Yeah, no.
Justice
GA
for
because of the ad interim measure, the order has been passed for holding the election. Now your lordship are going to pass the final and in confirmation of the election. Then your lordship have taken note in my opposition.
No, GA 42.
Yes, we have used the evidence in opposition. Now that observation.
Confirmation of report.
So,
My GA 42 has only come up for confirmation of
Okay,
report.
in GA for you, whatever opposition you have filed with, you have filed in the other applications, and those applications are disposed.
42, I have filed a opposition.
42 opposition. Where is your opposition in 42?
Yes. All
In 42?
yes, considered.
No, GA 40 just GA 42. He has filed opposition.
Yes,
Before hearing.
Before.
My lord,
That has been
what
considered.
he has
Not
said,
an order has been
my
made.
lord,
Third away.
That was considered.
no consideration. I make submission on submission. Our fee
Well, after
GA has
submission.
been disposed of, rejected. Now we have filed now pending only 42.
Yes.
42, there are the opposition. So now today a final order is going to.
Okay, let me see. Let me see the copy of the opposition.
Yes,
Just
your
a
lordship,
minute.
kindly see the order.
May I just say?
Your
this?
lordship, kindly see the
Your
opposition.
Just give me a copy, please. I shall see it. I shall consider it.
Yes.
Either I shall accept it or I shall reject it.
Yes. Then your lordship again.
This is GA 42.
একটা ওয়েতে বলতে দাও।
So this was okay. GA 42.
Yes.
GA 42. Okay, this is okay.
So now my respectful submission,
lord,
what has been passed, I have no.
My lord,
The
apart,
division bench order,
my lord,
what order passed, kindly see. The appeal court. The appeal court, this plea was taken before the appeal court. The appeal court said.
Anyway, I shall consider your affidavit, please. No more submissions.
So now my place me my submission information.
Your affidavit is there. That is your submission.
Because of that, evidently, I will show point of law is involved.
No. Whatever law you see, I am not consider. I'm concerned because there is no stay order. At the end of the
But
day.
I am not on that. So whether stay order has been passed by the division bench of the field bench or by appellate court, I am not concerned about. I am concerned about with regard to GA 42 is the suppression of material fact.
Okay, I shall consider that. Yes. If it is a yes,
my submission.
I have not passed any order. I shall pass. No, I am not passing any order today. I shall pass order after 2 days. If I find there is suppression of
Opportunity.
no further opportunity, whatever is there,
Certain judgment of the because of
you whatever you want to take, you take it before the appeal court.
No. These are appeal. I have come with the subsequent new bill. Is the point of law. I have the right to audience.
No, not in this GA 42.
Let this confirmation be dealt by the division.
Okay.
Why? Why?
Why they are objecting?
Learned, Mr. Banerjee, learned advocate appearing for the trustees.
yes.
And you are appearing for?
I am appearing for the appellant, my lord, item, my lord, GA number.
No. This GA 42, you are appearing for?
He's not nobody in GA 42.
I am not, nobody.
Yes, you are appearing in GA 42?
Is intervener. I have been given a chance because of one of
Existing Shabai?
হ্যাঁ সেটা বলো না
Okay. Mr. Janna, you give your name. Appearing for the existing Shabais are present. Hard learned advocates. Date GA 42 of 2025. Appear for orders on 22/7/2025. 22.
মঙ্গলবার 21শে জুলাইয়ের পরে মঙ্গলবার
So, my lord, may I take back? My lord, the opposition which has handed over because of the
You can give a thesis also, you see, but I have to yes. You just sort it out, give whatever is relevant, sort it out from here, give whatever is relevant and take back the rest.
And I handed over the Xerox copy also.
But the 4 p.m. fixed.
Yes.
The 4 p.m. fixed matter.
Item 53?
Yeah, of course.
4 p.m. fixed. Amar.
very short prayer.
Item?
Opposition 4 p.m.
Yes.
এগুলো সব আমাদের।
Yes, yes. It was fixed for?
It was fixed for yesterday. It was fixed, but
এটা আমার।
I could not able to come. I'm sorry.
আমার copy।
Today is a fix for only that matter. My lord, is already the
এগুলো judge এর।
original the plaintiff. The
ও নিয়ে নিল appeal court এর
was
ব্যবস্থা।
expired.
ওর কাছে আছে কি?
Already, that your lordship is appointed and appointed 17 June. The Mr.
এইটা, এইটা।
Partho Sarathi Basu is the witness commission.
এইটাই।
But that already expired is the original. The plaintiff's husband is already expired.
May I cut it short? Lord, Lordship had been pleased to appoint a commissioner for recording of the evidence of PW2.
Yes.
The PW2 has subsequently passed away.
Yes, yes.
So the commissioner has to be discharged. That's one. Second, Lord, they have to inform us whether they have any other witness. Otherwise, we'll proceed with our side of evidence.
So I'm adjourning it for 1 week, okay?
That is why my friend is seeking time, I guess.
For instead of 1 actually, because they
no,
now
sir.
they now says female they have
Okay, item 53 on the prayer of learned advocates.
For the
matters-
plaintiff. For the
Matter
plaintiff.
stands
stands adjourned till 31/7/2025.
কোন ডেটে ফিক্স হয়েছে দাদা?
কবে রাখলেন?
কোন ডেটে?